in the middle. But always in the middle, but never, not always not on a middle path.
My friend will start. What has happened is in the judgments which are uploaded, some of the judgments on which all of us will rely, that is Satyanarayan, Deepak Agarwal, Vinay Mishra, Dheeraj Moore, SCR has been uploaded. Now, SCR's paras are totally different. Yesterday night. So what I've done is, of the 6 main judgments, I have made an SCC compilation so that your lordship can see that, because all our written submissions are also on SCC paragraph numbers.
Most of them, latest volume has been updated.
You can airdrop us also.
Which also has the SCC. It's there. Actually, my lord,
because these 6, everybody will be referring.
There is a circular which has created this confusion. That circular says for constitution benches, when you circulate judgments, it must be the SCR. In fact, I think your lordship should update that circular because because
We have a SCC. No?
yes, so the only 2 judgments that I will be referring from the SCR, my lord, are Chandramohan and Rameshwar Dayal, which are pre-SCC, pre-1969. I'll read those from the SCR. Remaining judgments that I refer to will be from the SCC.
So here in this, these 6.
Well, it's in fact, Rameshwar Dayal, for example, now my learned friend is putting SCC online, which is very different from SCR also.
No, so I'll refer it from the
You
SCR.
already stated that you will be referring to it from SCR.
Yes, Malad. So I'm just saying, Malad, because we've marked SCR as per the volume circulated by the nodal officers.
That is what he has already said.
Yes.
So at least when there is no dispute,
Yes.
when he has already said that he will be referring from SCR. Yes.
Lord, I appear for the petitioners in 501.4. Just give me the list. Point 5.
And
1.4. That is my lord Madhukar Singh. 0.5, Durgesh and another.
1 minute.
Then 0.6, 0.7 and 0.17.
Please repeat.
501.4, 0.5, 0.6, 0.7 and 0.17. Now, my lord, these are all persons who were civil judges, and as per the rules, they were not permitted to sit for the direct recruitment exam for district judges. So they filed writ petitions in the High Court, challenging those rules. They got interim orders under which, my lord, they were permitted to sit for the exam. And your lordship may just know, my lord, that 501.4, that Madhukar Singh, he is the topper of the 2014 exam, above all other advocates, etc. He topped that exam. And the petitioner number 2 in the 501.5, what's his name? Krishna Kumar. He is the topper, my lord, of the 2016 exam. These are all in.
Madhukar Singh is topper of?
Lord Madhukar Singh of the 2014 exam. This is in UP. And Krishna Kumar, who's the second petitioner in 501.5, is the topper of the 2016 exam. Just, Lord, by the way, not that anything will turn on the construction.
For 2017, again UP.
Yes, again UP. All these people are from UP, my lord.
Civil judges, Junior Division.
Yes. Now, my lord, the writ petitions were all dismissed on the ground of existing judgments at that time. Satyanarayan Singh, my lord, which is a 1986 judgment, and Deepak Agarwal. And that is how we are before your lordship. Lord, if your lordship straight away has the article 233, because this whole case rests on the construction of the article. And your lordship has, my lord, in 2 orders, framed 4 questions of law Your Lordship may just have a look at those questions of law. Order dated 12/8/25, Your Lordship had framed 2 questions, and then the order dated 12/9/25, 2 more questions were framed.
Where are they? 2 questions applied.
There were originally 2, then 2 more were framed.
What are the
But if in Mr. Datar's submission, my lord, all 4 are together, so that may be relevant. That is, my lord, page 32 of volume 1 of the compilation.
Point.
That has all the written submissions.
Believe is not that bulky as the earlier CD.
The written submissions are, we've kept them short, my lord, all our written submissions.
Yes.
Page 32, your lordship will find, my lord, where Mr. Datar's submissions start. In para 1.1 are the first 2 questions, whether a judicial officer who has already completed 7 years in bar being recruited for subordinate judicial services would be entitled for appointment as additional district judge against the bar vacancy. So this is somebody, my lord, who already had 7 years before becoming a civil judge. All my clients would not fall under this. They all, my lord, became civil judges before they completed 7 years at the bar. Then 2, whether the eligibility for appointment as a district judge is to be seen only at the time of appointment or at the time of application or both. Then 3, whether there is any eligibility prescribed for a person already in the judicial service of the union or state under Article 233(2) of the Constitution of India for being appointed as district judge. And 4, whether a person who has been civil judge for a period of 7 years or has been an advocate and civil judge for a combined period of 7 years or more than 7 years would be eligible for appointment as district judge under Article 233 of the Constitution of India. All my clients would fall under this category. The 4th category.
7 years of combined experience.
Yes, they all have 7 years of combined experience, including whatever they did as a lawyer before becoming civil judge or as civil judge or including both. Now, my lord, just have a look at the article.
You are concerned with which are these issues?
I'm
All
sorry.
the 4.
All the 4.
Yes,
According to him,
So,
if
Lord-
if clause 4 is answered in affirmative, then his client would be
yes,
Covered by
yes,
that.
yes, yes.
We are in 2 categories. One is covered by question 4, the other is by
That's
question.
right.
My clients are also in question 1. We have 7 years before being appointed as civil judges. And we say, we don't want any benefit of our service as civil judge. If we are appointed, we will quit and then we will join. So can we be disqualified?
1 minute.
Question 4 is.
Really important.
It says that you concentrate more on question number 4. Because in the event question number 4 is answered in the
All
affirmative.
the others get through.
Everybody will get it.
Right, right.
And first 3, question 3.
It's okay.
Eligibility.
Lord, your lordship will have a look at Article 233. It comes under, my lord, Chapter 4 of Part 4. Sorry, Chapter 6
Chapter
of
6.
Part 6, which is the subordinate courts. Part 6 deals with the judiciary. This is subordinate courts. Appointment of district judges. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of that state in consultation with the High Court exercising jurisdiction in relation to such state. 2, and we are concerned more with 2. A person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Now, my lord, 2 constructions have been made for this sub-article. Dheeraj Moore, etc., has said that when it says a person not already in the service of the union or the state, it means that he should not be in the service of the state, which according to us, my lord, is completely wrong. The way I read it,
According to you,
yes,
the requirement of 7 years
yes,
would be applicable only to an advocate who is not in service.
correct. Absolutely right. And therefore, my lord, this qualifies or Lord makes two categories of people eligible. One is those already in the,
And one who are already in the service of the
correct,
union and the
correct.
state.
So those, otherwise, my lord, our submission is that these words, not already in the service of the union or of the state, will become redundant. Your lordship may just look at my written submissions, my lord.
So according to you, then the provision in the constitution
Yes,
would have been that to be eligible to be appointed as a district judge, he has to be an advocate for 7 years.
correct.
That would have been the
Right.
the provision in the
If your lordship has, my lord, my written submission, which is page 1 of volume 1, and come to page 5. Page 5, my lord, about 6th line, I have quoted that part, Article 233(2) minus those words which my submission is would become superfluous or redundant if their construction were to be accepted. Now just read it, my lord, as I've taken off those words. A person shall only be eligible to be appointed a district judge if he has been for not less than 7 years and as advocate or pleader and is recommended by the High Court for appointment. This is what would have been sufficient if what they are saying is correct, namely that you have to be an advocate or a pleader. If you are a district judge today, then you cannot, or if you are a civil judge today, then you cannot be eligible. Then, my lord, those words have become completely redundant. So therefore, and it's a well accepted principle of law, that any construction of a statute, or in this case, the constitution,
which makes the provision redundant.
which makes any words redundant,
Or rather than each and every word
has to have some
given
meaning.
its meaning.
Correct, correct. Now, I have, my lord, I'm relying on 3 judgments for this proposition. First, my lord, this is in
Person in service is a judicial service.
Yes, that has been clarified by Chandra Mohan, because, my lord, the constitution didn't say it, but Chandra Mohan later qualified by saying, yes, service means judicial
It's a judicial
service.
service, yes.
Yes, yes, correct.
Why does it say union? Judicial service, why does it say about it? It's a
Because
set.
there is a historical concept, my lord. As I go along, I'll show your lordship how the history of this, my lord, appointment of district judges happened. That's why it says you.
Revenue officers were also eligible at that time
Correct.
for being elevated.
Correct, my lord. Till Chandra Mohan, all officers, in fact, I'll show your lordship, my lord, the act and the rules earlier, pre-constitution, who was eligible.
That's what was used by. Chandramohan says even if it's located in a later article, we use the same definition.
Yes, paragraphs.
588, page 588.
Para?
281. Interview page 281. Two more. One slowly.
Lord, if your lordship turns to volume 5, sub-volume 2. This is that volume 5 is the case law volume, my lord.
The new one.
It's there, my lord, in the compilation which has been uploaded. Volume 5, sub-volume 2. And this judgment starts at,
Which, Rameshwar?
no, my lord. I'll first only on the point that no words of a provision can be made redundant.
Federal law, but they just.
That's correct, my lord. So just one very quickly, one paragraph from that judgment. This judgment starts at page 580,
518.
580, my lord, and the relevant part is at 588. I'll just give your lordship the citation of the other two judgments which I am relying on for this proposition. I don't need to show it. As your lordship said, this is a well accepted principle. At page 588, my lord, between placetum D and E, in Quebec Railway,
1 minute. Soli Devi.
yes, Hansoli Devi. And I'm reading, my lord,
1 minute.
page 588, which is 281 of the
It begins
report.
at page
It begins, my lord, at page 580.
5.
80. And I'm reading, my lord, page 588. Just one very short 4 lines.
Yes.
Between placetum D and E, in Quebec Railway. Your lordship has that? In Quebec Railway, Light Heat and Power Company Limited versus Vandry, it had been observed that the legislature is deemed not to waste its words or to say anything in vain, and a construction which attributes redundancy to the legislature will not be accepted except for compelling reasons. Two other judgments, my lord, which are Rao Shiv Bahadur Singh, 1953, 2 SCC, page 111.
Rao Shivadur Singh.
1953, 2 SCC, page 111.
1 minute, 1 minute.
Yes, I'm sorry.
Rao Shivadur Singh versus.
Just take out the thing. State of UP.
Are they mentioned in your?
Yes, they are there in the compilation, my lord. Your lordship can take it that they are in volume 51. 51. First and second serial numbers.
Give us the page number
Yes, my lord. The first one is page 2
of the compilation.
of volume 51 of the compilation.
Yes.
And the second one is page 72. The first one, my lord, which is Ashwini Kumar Ghosh, the relevant paragraph is para
The
26.
first one is Rao Shivadur Singh or?
First one, my lord, in the compilation is Ashwini Kumar. Paragraph of that is 26. And Rao Shiv Bahadur Singh, which is at page 72 of the compilation, paragraph of that is 10.
Paragraph?
10.
And here para 26. In Ashwini Kumar, para
26, para 26. So therefore, my lord, any.
So you will get n number of judgments on this.
Yeah, correct. Your lordship is right. So,
No word about statute.
right. You can't attribute redundancy to the legislature. Why would they have added those words there? In fact, my lord, the history would make it
Yeah.
clear as to.
Does it become redundant according to you?
Lord, I had given your lordship, my lord, the same 233(2).
That only the advocate having a 7 years practice to accept it. Then the first part, there are a person who is not already in service of state and union. That will be rendered OTO.
More of a clarification according to them. Not OCS, that's what we get. According to them, probably it is only more of a clarificatory. They want one way of exclusive.
If they are saying, that it is only advocates who are eligible, then what is the use of saying, but government servants are not eligible? All sorts of people are not eligible. Why would you specifically lay down government servants are not eligible? Supposing the words that not be already being in the service of the union or the state were not there, and the only words were that a person has to be an advocate for 7 years, that in any case excludes those people not being in the service of the union or the state.
This way, you have to see whether it is clarificatory or not. Certain statute and even the constitution also which says it can combine both exclusion and inclusion.
Exactly.
We have tried to tell you, in the first part it excludes, and other part it includes.
Exactly.
Lord,
That one way, but therefore it will not become redundant that way. How
clarificate.
to interpret the provision is one thing.
Yes,
To say because of that it will become redundant may not be correct.
Lord, clarificatory would only be in a situation where there is any confusion. Now, Lord, in my written submission, I had,
You can very well say.
yes,
Is 233 232 wants to make it doubly clear that the law advocate should have 7 years, while the differentiating between the others. Therefore, this 7 years qualification is not foreseen for them. Therefore, you can apply it that way.
my Lord, construction.
This qualification of 7 years meant for only lawyers.
Yes,
And then it may not meant for the others. That may be the one way of argument. Or there are, on the contrary, their argument is going to be, yes, it is only meant for 7 years. In that process, they want to exclude this.
but they would be
Yes.
excluded anyway.
Yes, yes.
Supposing, my Lord, just have.
Only a language, we want to see the ultimate meaning what is conveyed. There is no exclusion per se that way. It's only the understanding of the provision.
First, try to
Yes,
let them at least read.
Now, my Lord, next I want to take your Lordship to a little bit of, Lord,
Yes.
history. Lord, under the Indian Civil Services Act, where is that page? Fancy volume, eh? If your Lordship has volume 4 of the compilation, this is, my Lord, at page 12 of volume 4 is the Indian Civil Services Act. I'm sorry for the poor print. We couldn't get a better print anywhere. You have that copies of that other thing? If your Lordship has, my Lord, page 12 of that compilation, volume 4, Indian Civil Services Act 1861. Actually, we had a better print, but it didn't have the heading, the Indian Civil Services Act, so it was a little confusing.
Yes.
If your Lordship has, my Lord, on the same page, section 2,
All vacancies happening in any.
yes, all vacancies happening in any of the offices, places, or employment specified in the schedule annexed to this act, and all such, what is this? Offices which may be created hereafter shall
We filled up.
be filled up and supplied except as hereunder provided from amongst the, what is it? Covenanted civil servants
Among
of the
the-
crown in India.
Wanted staff, civil services.
From
the
amongst
crown
the
in-
covenanted civil servants of the crown in India. So, and if your Lordship has the next page, the schedule, under judicial, the posts are civil and sessions judge, which is today the district judge and sessions judge, or chief judicial officers of districts in the provinces now known as regulation provinces, additional and assistant judges in the said provinces. So, my Lord, for these posts, only persons from the civil services could be appointed. That was the position in 1861. So there was no question of any, my Lord, lawyers, etc. It was only from civil services that district judges could be appointed at that stage. Then your Lordship may have, my Lord, the Government of India Act 1915, which is at page 47 of this compilation. It starts a little earlier, but I'm reading, my lord, section 98 and 99, which is at page 47 of the compilation. The lordship has that, my lord? Section 98 at page 47. Subject to the provisions of this act, section 98 I'm reading.
Yes.
Subject to the provisions of this act, all vacancies happening in any of the offices specified or referred to in the third schedule, and I'll just show the third schedule that includes this district judge, etc. And all such offices which may be created hereafter shall be filled from amongst the members of the Indian Civil Service. Then there is a kind of a proviso, that next section, section 99. The authorities in India by whom appointments are made to offices in the Indian Civil Service may appoint to any such office any person of proved merit and ability, domiciled in British India and born in British India, of parents habitually resident in India and not established there for temporary purposes only, although the person so appointed has not been admitted to that service in accordance with the foregoing provisions of this act. So there is a power to appoint people who are not in the Indian Civil Service, and that is to be done by rules, which is 99(2). Every such appointment shall be made subject to such rules as may be prescribed by the Governor General in Council and sanctioned by the Secretary of State in Council with the concurrence of a majority of votes at a meeting of the Council of India. And the third schedule your lordship will find at page 61. That is that these offices normally from the civil services, but the authorities can appoint from others also as per rules. And these offices include, my lord, at page 61, part 2 of that bottom, offices in the provinces which were known in the year 1861 as regulation provinces. 7, district and sessions judges. 8, additional district or sessions judge and assistant sessions judge. Now the rules are very important, and that is, my lord, at page 100 of this compilation. This is the notification dated 30th March 1922 as amended by notification dated 17th May. Lord, that handwritten correction is on the website of the government itself. This is how it is there. Now, Rule 1 says, with the previous sanction of the Governor General in Council and of the Secretary of State in Council and local government may, by notification in the official gazette, declare the number of superior executive and judicial officers being offices ordinarily filled from amongst the members of the Indian Civil Service, to which, subject to the provisions of subsection 1 of section 99 of the Government of India Act, persons not being members of the Indian Civil Service may be appointed. 2, within the limit of the number declared under Rule 1, the local government may appoint, and your lordship will straight away have Roman 2 because Roman 1 refers to executive office. 2, to a superior judicial office, a member of the provincial civil service, subordinate to the local government, or a person who at the time of the appointment is a barrister of England or Ireland, or a member of the faculty of advocates in Scotland, or B, a vakil, pleader, advocate or attorney of a high court in India, or C, a pleader or advocate of a chief court or of a judicial commissioner's court, or D, a pleader of a district court, etc., etc. So therefore, my lord, two streams are very clear. One, that he is a person, a member of the provincial civil service, subordinate to the local government, or a person who is a barrister, vakil, pleader, etc. So this is the history of how Lord 233 has come. Those two streams, namely a person who is a member of the provincial civil service,
But whether the superior judicial service is defined,
that your lordship saw, my lord, in the third schedule to the Act, the Government of India Act 1915. That was, my lord, at page.
it says offices in the provinces which were known in the year 1816 as regulation provinces.
So these are the regulations made under, these are the rules, my lord, made under section 99(2). If your lordship comes back to the Government of India Act 1915.
1992, so which permits even those persons who are not in Indian civil services and who are,
Yes, correct.
who are
correct. So
domiciled
therefore,
to be appointed.
so even at this stage in 1915, 1922, 23, those who were in the civil service could be appointed district
Yes.
judges. But apart from that, those who were in the provincial service or those who were advocates, barristers, vakils, pleaders, etc. That came by way of, my lord, the rules made under this 1915 Act. So that, my lord, the notification of 1923, namely either member of a provincial civil service subordinate to the local government or a person who was a barrister, vakil, pleader, etc., came by this. And that is how, my lord, when the Government of India Act 1935 came, Article 254, which is the precursor to 233 in our constitution, my lord, came, which is more or less the same. Your lordship will have a look at it at page 136 of this compilation. (254) of the Government of India Act 1935. District judges, etc. Appointments of persons to be and the posting and promotion of district judges in any province shall be made by the governor of the province exercising his individual judgment, and the High Court shall be consulted before a recommendation as to the making of any such appointment is submitted to the governor. To a person not already in the service of His Majesty shall only be eligible to be appointed a district judge if he has been for not less than 5 years a barrister, member of the Faculty of Advocates in Scotland, or a pleader, and is recommended by the High Court for appointment. So more or less identical, except that 7 years is 5 years. So this is, my lord, how 233 came pursuant to. So the history of it shows that initially,
Corrective, the Article 1 and 2
yes,
are drawn from 254, 1 and 2.
yes. And 254 of the Government of India Act, my lord, was from the earlier thing, namely where people from the civil service were, eligible to be appointed. Provincial civil, initially only ICS.
According to even after 1935,
Yes,
the practice of people being appointed from the ICS,
yes,
also from the bar,
yes.
that continued.
That continued, not just the ICS, also from the provincial civil services, from the civil services. So a person not already in the service of His Majesty shall only be eligible. So therefore, my lord, this has been coming from that period, and this is the background in which your lordship has to interpret 233. Why it said a person not already in the service. Namely, a person who is already in the service is eligible anyway. A person not already in the service is eligible if he has been an advocate for 7 years. And that ties in, my lord, with my submission that otherwise it would make those words redundant. Then, my lord, before I take your lordship to Rameshwar Dayal and Chandra Mohan, which are the two most important judgments.
260 of the Constituent debate.
Before I take your lordship to those two very important constitution bench judgments, I want to show, my lord, what happened in the Constituent Assembly debates.
Yes, that is.
Although not very much happened, but there is something relevant. So if your lordship has, my lord, page 259 of this volume 1, that volume 5, volume 4, the same volume that your lordship was reading just now. Page 259. Towards the bottom of the page, the last 7 or 8 lines, Article 209A. Does your lordship have that, my lord? 209A was the draft article which became 233. Yes. Does your lordship have that page, my lord? 259?
Yes.
Yeah, I'm sorry. The Honorable Dr. B.R. Ambedkar. Sir, I move that after Article 209 between chapters 7 and 9 of Part 6, the following be inserted. And then 209A is quoted, which is identical to 233. And then, my lord, on the next page, 260, if your lordship has just below the middle of the page, paragraph beginning, sir, the objects. After, my lord, the entire thing is quoted up to 209F, which takes us to, my lord, 237. Just below 209, at page, my lord, 260, the last paragraph, sir, the object.
Yes.
I'm reading that part. Sir, the object of these provisions is twofold. First of all, Lord, the last paragraph on page 260. Sir, the object of these provisions is twofold. First of all, to make provision for the appointment of district judges and subordinate judges and their qualifications. So therefore, my lord, this article provides for qualifications of district judges. Whether now appointment of district judges would include whether it is by way of direct recruitment or promotion. Appointment is to a post there are two ways of getting appointed to that post, either direct recruitment or promotion. So if you are laying down qualifications to be appointed district judge, and that qualification, as my learned friends on the other side would say, is only 7 years an advocate and not being in the service, then, my lord, how can civil judges even be promoted to district judges if the qualification is only, according to them, 7 years an advocate? Because, as your lordship sees, my lord, from these debates, this article is laying down the qualifications as well. And if you limit the qualification, if you take away those in the service, those in the judicial service, which is what we are reading, then, my lord, it leaves only 7 years an advocate. So how can a civil judge even be promoted to district judge? Because then he's not qualified.
You respect, they are not saying so.
I'm sorry, my lord.
Nobody's saying.
Saying so.
Nobody's saying.
They are not saying, they're saying that they are only saying how to reckon the 7 years. That's the only thing. You can, that is, 7 years means only as a lawyer you should be there. That's
So
all.
they are saying that
Promotion, they are
233.2.
saying.
Lord, let's see what they are saying. Just come back to 233.2.
It has to be very clear. They are not making that statement. What they are saying is that.
No, they may not be saying it.
There's no problem.
They, but because
But-
they are saying,
This only with five says.
they are saying, my lord, that civil judges are applicable, are eligible for promotion. But what I am submitting before your lordship is this. If, as Dr. Ambedkar says, this entire lot of articles from 209A to 209F, which is 233 to 237, lays down the qualification of district judges, a qualification of persons to be appointed district judges. That qualification is only in 233.2. Nowhere else. None of the other articles says that. Now, how do we read 233.2? They say that 233.2 is excluding civil judges, and the only qualification that is prescribed is 7 years an advocate. If that is the case, my lord, I ask myself the question, then how do civil judges get promoted? Because that's also an appointment. They cannot get promoted. The object of 233.2 is to lay down the qualifications. No,
Well, let us put their case. Their case is simple. 233 alone you commanded. 233 is meant for them. It's as simple as that. For that purpose, it makes clear, it excludes the somebody who's in employment of state and civil union. That's the thing.
I'll meet that also. I'll meet that also.
The argument would only be, it is not their argument, therefore we do not blabber much on that.
That would not be the argument.
What they are saying is for the direct recruitment, the 7 years is only for the lawyers alone. That 7 years qualification, they have been excluded from 233.2, not 233.1.
Therefore, my lord,
233.1 speaks about promotion.
correct.
It can be
Now,
done.
so therefore, my lord, according to them, where does the eligibility of civil judges come from under these articles? Because obviously they have to be eligible for being promoted. They have to be eligible for being promoted, Where is that eligibility coming from? According to me, that eligibility is, even if they were to be promoted, for a moment, let us argue against me, my lord, that their only avenue is promotion. Where is that eligibility laid down in Article 233, 234, 235, 236, 237? According to me, there is no other place except 233.2.
No, 233 deals only with the district judges.
Correct?
Then 234 deals with the recruitment of persons other than the judges.
Yes,
It provides for making of the rule.
right. Therefore, are they saying that the eligibility of civil judges to become district judges is coming only by way of the rules? In my humble submission, that's why I referred to, my lord, the Constituent Assembly debates, namely that these articles are providing for the qualifications for being appointed as district judge. And that, in my humble submission, would include the qualifications for being promoted as district judge also, because promotion is also appointment. Appointment is,
Word also use promotion. Words used in sub-article 1
yes,
also use the appointment, posting and promotion.
yes. So therefore, my lord, your lordship is right. But generally, the appointment includes, in fact, my lord, under the UP Judicial Service rules, your lordship may straight away have that, my lord, the Higher Judicial Service rules. Please have a look at page 419. Same compilation, same volume.
490.
419. This is the UP Higher Judicial Service Rules, 1975. As amended from time to time. This comes under Part 4, Procedure for Direct Recruitment. And your lordship will find Rule 18 at the bottom of page 419 is Procedure of Selection. That is direct recruitment.
Direct recruitment for what?
for district judges. And then your lordship will have on the next page, part 5, rule 20, promotion of members of the Nyayik Seva as referred to in rule 5A. And then, my lord, straight away come to rule 22 at page 421 bottom. Appointment. Subject to the provisions of sub-rule 2, the governor shall, on receipt from the court of the list mentioned in rules 18, 20, and 21, make appointments to the service on occurrence of substantive vacancies. 18 refers to direct recruitment, 20, 21 refer to promotions, all of which comprise appointments. In fact, when a person is promoted to district judge, his promotion order reads as you have been appointed as district judge. नियुक्त किया जाता है.
Try to understand and we'll
Yes.
put it to you how it is.
Lordship, please.
There are two provision in 233, 1 and 2. One confines to only to the judicial officers on promotion, or even take it for appointment. That does not prescribe any other qualification or eligibility criteria, correct? Now, Rule 33, Section Article 233 2 speaks about the lawyers other than those who are in employment of state or union. So what, in other words, what you are saying is this. Article 233(1) speaks about the appointment for promotion. It includes promotion of a judge who is already on roll.
No, my lord, just read 233(1) with me. It doesn't say civil judge there.
All right.
That's a general, in fact, my lord, what?
Whatever it may be, we take it.
Right,
We'll take it.
right.
See, perhaps we can appreciate your argument if you say 233(2) is the only article which speaks about eligibility criteria.
Correct. That's what
So,
I'm saying.
Therefore,
Right.
that is in common.
Correct, my lord. That's exactly my point.
233,
That's my submission. I'm-
233, Article 233(1), we'll put it this way. Article
Yes, yes.
231 does not speak about lawyers, correct?
It does not speak about civil judges as well. That's a general power.
We will not go into that, that's
Correct.
redundant now, irrelevant now.
Correct.
So we are only concerned with the issue between lawyers and the judges
Civil judges.
with
yes.
respect to the direct recruitment. That's
Lordship.
why I said promotion, we will not go into the other things.
Right,
There are
right,
two channels, we
right.
will not go into it.
No, so,
So nothing much can be said about 233(1). Where 233(2) it says, it speaks about for the first time about the lawyers. It speaks about, according to you, it speaks about the right of a lawyer to write the examination to be qualified for the direct recruitment. Only to that
right,
time
correct,
alone.
my lord.
In that qualification is fixed at 7 years. So therefore, your argument, as we understand, is that then in 233(1), which does not prohibit the participation of a common servant, or whoever it may be, from being considered for direct recruitment. This qualification prescribed and under 233(2), ipsa photo will be imported into that. To that extent, we agree. That's
correct.
what. That's
Now, my lord, the only additional point that
Let us not go into the rules because the rules may be different for every
Yes.
state. Let us confine also to the interpretation of the Constitution.
right.
You can't import the provisions of rules to interpret a
In
Constitution.
fact, that's something which, my lord, I completely agree with your lordship, my lord. In fact, that is something, the point of whether you can use rules to interpret a provision of an act or even of the constitution. I have been looking for law, my lord, on this aspect that the act or the constitution can be interpreted only directly. You can't use what rule has been framed to interpret that. Otherwise, the position would be
Otherwise,
that you can change a rule and therefore change the meaning of the act or the constitution.
So let us,
So I have,
let us restrict also to the interpretation of the.
yeah, correct. So therefore, my lord, leave aside the rules for a moment. I am only saying this, that as Dr. Ambedkar said, this article prescribes the
According to
qualification.
you, Article 233 prescribes for appointment, posting and promotion of the district judges.
Yes, my lord.
And
And therefore the qualification.
And if the contention is to be accepted,
Yes.
then there can't be one promotion by of a civil judge to the district judge.
No, my lord, I'm not saying that. I'm not saying that a person can't be promoted. Yes, he can be promoted. I am saying something a little different. If this is prescribing the qualification, then where is the only qualification that Article 233, my lord, provides is 7 years an advocate? Or that you are, if I'm correct, then 233(2) also prescribes that or you are in the service, which has been not interpreted to mean the judicial service. So therefore, if you say that I am wrong in saying that 233(2) provides for judicial service and doesn't exclude it, and that if they are right in saying it excludes it, then where is the qualification for civil judges in this article? I am saying that there is no qualification therefore prescribed for civil judges because they can't be 7 years an advocate. I'm using that as an aid to say that therefore 233(2) refers to two streams. One, that either you are in the service of the Union of the States, which means judicial service, or you are an advocate. If you take the construction that they are, my lord, espousing, namely that no, 233(2) excludes those who are in service and includes only those who are 7 years an advocate, then in which case, my lord, civil judges will not be eligible to become district judges, even by promotion, is my submission.
That's what we also put it to you, in different. You are now only one hour left. So
Yes, I'll finish in 1 hour. I'll finish in 1 hour. Now, my lord, straight away, your lordship will come to those two judgments. Just before that, my lord, Shetty Commission will come to later. Just come to those two judgments. First have Rameshwar Dayal, volume 5(1), page 98. If your lordship, my lord, turns to page 100, that's where the judgment starts. A writ was filed, my lord. This just gives the background facts, and I won't read it, my lord. I'll just tell your lordship what they are saying. A writ was filed challenging the appointment of 5 persons as district judges. That writ was dismissed by the High Court, and the ground taken was, and that's towards the bottom of the page at page 100, that they were not qualified to be appointed as district judges under Article 233 of the Constitution at the time when they were appointed by the state government. And therefore, the appointment as such was constitutionally invalid. Now, the facts, my lord, have been, this, my lord, incidentally, as your lordship might note, my lord, that included the appointment of Justice H.R. Khanna, which your lordship will find at the bottom of page 100.
page 100.
Page 100 of that compilation, at the bottom, your lordship will find that one of those 5 people whose appointments was challenged was also.
Compilation.
I'm volume 5, 1. I'm so sorry. The judgment starts at page 98 of this compilation.
You have also given SCC online. So
I have not given that, my lord. I was reading it from the SCR because both these Constitution bench judgments were pre-SCC.
okay.
So later they have been. SCC started in 69. So anything before that, my lord, was not originally in the SCC. Now SCC has kind of taken those judgments and put it in.
Yes, volume page 100.
Page 100, my lord, the judgment starts, and the background facts were that 5 people were appointed as district judges. Their appointments were challenged on the ground that they were not eligible under 233. Now, I was just, Lord, pointing out just as a matter of interest that one of the 5 was Justice H.R. Khanna, who was District and Sessions Judge, Delhi, who later, Lord, came here, whose portrait hangs in Court 2. Then your lordship will have, my lord, page 100 and the points for consideration at page the 879, if your lordship has. at page 103.
Yes.
Your Lordship will have the facts of two of these people. Paragraph 5 at the bottom. Respondent 6, P.R. Sawhney, was called to the bar on November 17th, 1930. He was enrolled as an advocate of the Lahore High Court.
I think the issue was whether the practice at Lahore would be taken into consideration.
That was not the only issue. One of the issues was that they were working in the government at the time of their appointment, and therefore would they be eligible at all? Your Lordship is right. That was one of the issues. Namely, their practice at Lahore, would it count or not? So that would apply to Lord H.R. Khanna, etc.
Yes.
But-
Referring to which volume?
Volume
What
5,
about-
sub-volume 1. Volume 5, sub-volume 1. The judgments are in volume 5, my lord. Sub-volume 1 is the very first one of those.
From page to page 401.
So it's like a V1.
VA and VR. Volume VA, VR.
Yes,
I'm so sorry.
105.
103 or
Yes,
respondent PR.
yes.
Sawhney.
Was called to the bar on November 17, 1930, was enrolled as an advocate of the Lahore High Court on March 10, 1931. After partition, he shifted to Delhi, worked for some time as legal advisor to the custodian evacuee property. Then he practiced for some time at Delhi. He then accepted service under the Ministry of Rehabilitation as an officer on special duty and administrator, Rajpura Township. On March 30, 1949, he became the chairman, Jalandhar Improvement Trust. On March 6, 1949, he got his license to practice as an advocate suspended. On April 6, 1957, he was appointed as district and sessions judge while he was, my lord, the chairman of the Jalandhar Improvement Trust. So he was in the service of the union or the state or whatever it was, and he was not an advocate. In fact, he had got his license also suspended and he got appointed. So the question was whether he was eligible or not. Now, also, my lord, at page 103, top paragraph 2, Harbans Singh, he was then the deputy custodian of evacuee property when he was appointed district and sessions judge. So these two people were not lawyers, my lord. They had been lawyers earlier, but were not lawyers at the stage when they got appointed as district judges. Now, if your lordship, my lord, turns to the next page, 104.
Right. Same thing is what with respondent to Urban Singh.
That's right. That's right. That's correct, my lord. He was respondent number 3, Harbans Singh, 103 top.
And the question with regard to Justice H.R. Khanna
Yes,
was with regard to whether his practice at Lahore
Right.
should be
correct,
taken into
correct.
consideration.
So that was a separate
completing
question.
the total.
Absolutely right. Absolutely right. So that, my lord, we are not concerned with whether his practice at Lahore. That was, of course, my lord.
Now, after
Now, my lord,
the
at
only
page.
question is whether the service of Sawhney
Yes. And
and
Harbans Singh. Harbans Singh.
in the government,
Yes,
which was not a judicial service,
correct.
could have been taken into consideration or not.
Not taken into consideration. When they were appointed, they were not lawyers. One of them had got his license suspended and they were working there. He was chairman of the Jalandhar Improvement Trust. Question is, are you eligible? And therefore, my lord, the question of the 233(2), either in the service or advocate of 7 years, that question therefore arose. Now, just have a look at, my lord, 104(2), 104 about.
Yes.
Your Lordship has page 104,
Yes.
about sixth line from the top. Two of them, Harbans Singh and P.R. Sawhney, did not have their names factually on the roll when they were appointed as district judges. Your Lordship has that sentence, Manoj?
Which line?
About eighth line, seventh line from the top. Two of them, Harbans Singh and P.R. Sawhney.
P.R. Sawhney.
Yes, did not have their names factually on the roll when they were appointed as district judges because they were not working in the government.
Yeah.
One of them was the chairman of the Improvement Trust. The other person was custodian of evacuee property. Now, my lord, Article 233 is quoted on that page, and immediately after 233(2) has been quoted, now the argument of learned counsel for the appellant has ranged over a wide field, but the point for decision is a narrow one and depends on whether respondents 2 to 6 fulfilled the requirements of clause 2 of Article 233 of the Constitution when they were appointed as district judges by respondent 1. Then your Lordship may have, my lord, page 110.
Two and six, they are one part, and
Yeah.
3 and 4, the other part.
I'm sorry.
2 and 6, they fall in one category,
Yes,
and 3 and 4, they fall in other category.
right, correct.
3 and 4 with regard to their experience at Lahore,
Yes.
and 2 and 6 as to whether their service can be considered.
I think, my lord, this Harbans Singh was respondent number 3 and 6. The paragraph is,
Urban was number 2.
Lord, if your Lordship has page 103, top of the page, respondent 3,
Number
Harbans
3.
Singh.
Respond number 3,
Yes.
Urban Singh.
Now, if your Lordship turns to page 110,
Yes.
articles about, my lord, 10 lines from the bottom. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article
You
230.
are at page 108.
110, my lord. I'm so sorry. Because before that, my lord, the discussion is about that Lahore part. That was, we are not concerned with that. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article 233. And we do not think that Clause 2 of Article 233 can be interpreted in the light of explanations added to Article 124 and 217. Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down, and under clause 1, the governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not already in the service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. The clause does not say how that standing must be reckoned, and if an advocate of Punjab High Court, etc., then skip that part, my lord, and then come to the bottom of page 111. We now turn to the other two respondents, Harbans Singh and P.R. Sawhney, whose names were not factually on the roll of advocates at the time they were appointed as district judges. What is their position? We consider that they also fulfilled the requirement of Article 233 of the Constitution. Harbans Singh was in the service of the state at the time of his appointment, and Mr. Vishwanath Shastri, appearing for him, has submitted that clause 2 of Article 233 did not apply. So therefore, if he was in the service, then itself he is eligible. And this was a direct recruitment, not a promotion. So that is one ground that is given by the Constitution bench. The other ground is the next sentence. We consider that even if we proceed on the footing that both these persons were recruited from the bar and their appointment has to be tested by the requirements of clause 2, we must hold that they fulfilled those requirements. They were advocates enrolled in the Lahore High Court, etc., and that their practice of 7 years would be counted. So the two grounds are given. One, that because they were in the service, therefore they fulfilled it. Because, my lord, 233(2) was read in the manner in which I am reading it. Namely, that two kinds of people are eligible. One, that those who are already in the service, and two, advocates of 7 years. So both the reasonings have been given in this judgment to, Lord, make them qualify. to not set aside their appointments. Number one, since they were in the service, they qualified. And number two, in any case, their prior experience,
No, but then, even though they were not in the judicial services,
correct, because that plot came only by way of Chandra Mohan.
then no.
Yeah, that came only later, because till then your lordship saw.
But then what is most important to you
Yes,
is observations in page 110, last 7-8 lines.
yes. Yes, Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down. Absolutely right, Manoj. Absolutely right.
But how does Dhiraj More distinguish this?
I'll show your lordship, my lord. It just says, no, this is something totally different. I don't know how it's been distinguished. Chandramohan is even clearer. I'll show to your lordship Chandramohan.
Let us go to Chandramohan.
Yes, straight away, my lord. Now, Chandramohan is, my lord,
Because this was 5 judges.
both of them are 5 judges.
This was also 5 judges.
This is also 5 judges. Chandramohan is also 5 judges. Both were binding, my lord, on Dhiraj Mohan.
Binding on Dhiraj More.
Yes, absolutely right. Page 180, my lord, of the very same compilation, your lordship will find Chandramohan. If your lordship turns to page 183, that's where the judgment starts. I'll just read that first paragraph, my lord, because there is a phrase called judicial officers who are actually from the executive department. That has created a bit of a confusion. In Dhiraj More, they say that this part goes against you because they hold that these judicial officers were not qualified. Judicial officers here, they state in this paragraph, was a euphemism used for those in the executive service. I'm reading, my lord, between placetum C and D on page 183. The facts may be briefly stated. During the years 1961 and 1962, the Registrar of the Allahabad High Court called for applications for recruitment to 10 vacancies in the UP Higher Judicial Services from barristers, advocates, vakils, and pleaders of more than 7 years standing, and from judicial officers. The expression judicial officers is a euphemism for the members of the executive department to discharge some revenue and magisterial duties. Selection committee constituted, etc. Then, my lord, between placetum E and F, respondents 2, 3, and 4 were advocates, respondents 5, 6, and 7 were judicial officers. Then, my lord, at placetum G, thereafter the appellant who belongs to the UP Civil Services Judicial Branch, who was at the time acting as district judge, and others who were similarly situated as the appellant, filed petitions on the High Court at Allahabad under 226 for an appropriate writ directing the government not to make the appointments to the UP Higher Judicial Service pursuant to the said selection. So he didn't say that appoint me or that I was eligible or that I should have been permitted to sit in the exam. He only challenged the appointments of those persons. Then your lordship may have, my lord, 2 pages later at page 185. Placetum C, the argument of learned counsel for the appellant may be placed conveniently under the following 5 heads. 1. While under Article 233(1) of the Constitution, the governor has to make appointment of persons to be and the posting and promotions of district judges in consultation with the High Court concerned under the rules made by the governor under Article 309 of the Constitution. He has to consult before making such appointments a selection committee constituted thereunder, and therefore the appointments made in consultation with 2 authorities instead of 1 as provided by the Constitution were illegal. 2, on a fair reading of the provision of the rules, it is manifest that the High Court is a transmitting authority, etc. Just leave that, my lord, for the sake of time. Just come to 3.
The governor has no
Yes,
power.
the governor has no power to appoint district judges from judicial officers as they are not members of the judicial service. The exclusion of the members of the judicial service in the matter of direct recruitment offends Articles 14 and 16 of the Constitution, or alternatively, the exclusion of members of the judicial service in the matter of direct recruitment to the post of district judges while permitting judicial officers to be so recruited offends the said article. Then, my lord, your lordship will have page 189. Placetum F. The third point. The third point raised is one of far-reaching importance. Can the governor, after the constitution, directly appoint persons from a service other than a judicial service as district judges in consultation with the High Court? Can he appoint judicial officers as district judges? The expression judicial officers is a misleading one. It is common case that they belong to the executive branch of the government, though they perform certain revenue and magisterial functions. The relevant article on which both parties rely is Article 233, then that is quoted. Then your lordship will have the next page. While the learned counsel for the appellant contends that the said article must be read along with the group of articles embodied in Chapter 6 of Part 6 of the Constitution and also in the background of the history of the said provisions, and that if so read, it would be clear that the governor can only appoint district judges either from the judicial service or from the bar. The learned counsel for the respondents, on the other hand, argues that Article 233 is expressed in general terms and there is no warrant to restrict the scope of the said article by construction or otherwise. Then your lordship will have, my lord, 2 pages later, page 192, after, my lord, the various other articles in that same part are quoted.
No, you can read to the third paragraph also, that is also important.
Which one? I'm sorry.
Page 190,
190. Yes.
before construing the said provision.
Before construing the said provisions, it should be remembered that the fundamental rule of interpretation is the same whether one construes the provisions of the Constitution or an Act of Parliament, namely that the court will have to find out the expressed intention from the words of the Constitution or the Act, as the case may be. But if, however, two constructions are possible, then the court must adopt that which will ensure smooth and harmonious working of the Constitution and eschew the other which will lead to absurdity or give rise to practical inconvenience or make well-established provisions of existing law nugatory. Grateful. Then, my lord, may I take your lordship to 192? After that whole chapter in the Constitution is quoted. Third line, top of the page. Page 192, third line from the top. The gist of the said provisions may be stated thus. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state. There are two sources of recruitment, namely one, service of the union or the state, and two, members of the bar. Please mark this, my lord. Two sources of recruitment. The said judges from the first source are appointed in consultation with the High Court, and those from the second source are appointed on the recommendation of the High Court. The article doesn't say that the first source will be only by way of promotion. That will be in consultation, because under
That may
230,
be their argument.
and that it is only by way of promotion. That is only their argument, and somehow it is not there anywhere in the article, but somehow it has come from somewhere. But in the case of appointments of persons to the judicial service other than as district judges, they will be made by the governor of the state in accordance with the rules framed by him in consultation with the High Court and the Public Service Commission. But the High Court has control over all district courts and courts subordinate thereto, subject to certain prescribed limitations. So far, there is no dispute. But the real conflict rests on the question whether the governor can appoint as district judges persons from services other than the judicial service. That is to say, can he appoint a person who is in the police, excise, revenue, or such other service as a district judge? The acceptance of this position would take us back to the pre-independence days, and that too in the conditions prevailing in the princely states. In the princely states, one used to come across appointments to the judicial service from police and other departments. This would also cut across the well-knit scheme of the Constitution and the principle underlying it, namely the judiciary shall be an independent service. Doubtless, if Article 233(1) stood alone, it may be argued that the governor may appoint any person as a district judge, whether legally qualified or not, if he belongs to any service under the state. But Article 233(1) is nothing more than a declaration of the general power of the governor in the matter of appointment of district judges. It does not lay down the qualifications of the candidates to be appointed or denote the sources from which the recruitment has to be made. But the sources of recruitment are indicated in clause 2 thereof. Under clause 2 of Article 233, two sources are given, namely one, persons in the service of the union of the state, and 2 advocate or pleader. Now, this is not just pausing here for a moment. They are interpreting 233(2), that under 233(2), 2 sources are given. One is persons in the service and the other is advocate or pleader. And yet, my Lord, Dheeraj Moore says, ki, no, 233(2) excludes those in service. Completely contrary to this. It does not lay down the qualification, but sources of recruitment are indicated, namely 1 persons in the service and 2 advocate or pleader. Can it be said that in the context of Chapter 6 of Part 6 of the Constitution, the service of the Union of the state means any service of the Union or of the state, or does it mean the judicial service of the Union or the state? The setting, that is the chapter dealing with subordinate courts in which the expression the service appears, indicates that the service mentioned therein is the service pertaining to courts. That apart, Article 236B defines the expression judicial service to mean a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. If this definition, instead of appearing in Article 236, is placed as a clause before Article 233(2), there cannot be any dispute that the service in Article 233(2) can only mean the judicial service. Namely, judicial service is included in Article 233(2). The circumstances that the definition of judicial service finds a place in the subsequent article does not necessarily lead to a contrary conclusion. The fact that in Article 233(2) the expression the service is used, whereas in Article 234 and 235 the expression judicial service is found, is not decisive of the question whether the expression the service in Article 233(2) must be something other than the judicial service. For the entire chapter is dealing with judicial service. The definition is exhaustive, etc. Then your Lordship will have just above placetum D, having defined judicial service in exclusive terms, having provided for appointments to that service, and having entrusted the control of the said service to the care of the High Court, the makers of the Constitution have not conferred a blanket power on the governor to appoint any person from any service as a district judge. Reliance is placed upon the decision of this court in Rameshwar Dayal in support of the contention that the service in Article 233(2) means any service under the state. The question in that case was whether a person whose name was in the roll of advocates of East Punjab High Court could be appointed as a district judge. In the course of the judgment, Justice S.K. Das, speaking for the court, observed, Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the Union of the state, no special qualifications are laid down. And under Clause 1, the governor can appoint such a person as a district judge in consultation with the relevant High Court. As to a person not already in service, a qualification is laid down in Clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. This passage is nothing more than a summary of the relevant provisions. The question whether the service in Article 233(2),
as a matter of fact, they depart from the view taken in Rameshwar Dayal. So,
to the extent, yeah, your Lordship is right, because that's
says that any service.
right. Because, my Lord, they had cleared people who were not in the judicial service, namely those two.
That was the situation then.
Correct.
Similar now.
That is correct. Your Lordship is absolutely right. As a matter of fact, they depart slightly to limit it to.
This is under the Constitution scheme.
They raise their foundation on the doctrine of
Yes.
separation of powers
Yes.
and independence of judiciary.
Correct.
Yes, sir.
Correct. But one thing is clear from both the judgments, that 233(2) includes both these streams. Both the judgments say it. And as your Lordship rightly asked, my Lord, how did Dheeraj Moore come to the conclusion that no, it's an exclusion rather than an inclusion? Then, my Lord,
Stream is something which is created by us, not under the Constitution. The Constitution merely says promotion and then direct recruitment, that's all. The qualification is time, and obviously lawyers cannot be considered for promotion because they are not working as judicial officers. There is no exclusion of judicial officer under 233(2).
yes.
I mean, if it is recruitment is there expressly.
Then, my Lord, that fourth question, can people in the judicial service be excluded? Your Lordship had seen questions 3 and 4 were relevant. So 3 they answer by saying that no, this has to be only the judicial service, not the executive service, not any other service. And 4 they leave open. They don't answer that at all. Can they be excluded? That your Lordship will find, my Lord, at page 195. The small 2-line paragraph between placetum C and D. In this view, it's not necessary to express our view on the last 2 questions. But naturally, the corollary of what they have held would be that you cannot exclude the judicial service. If there are two streams, one is the service, which means judicial service, and the other is advocates. In fact, I'll come to that in a moment, my lord. And that is the next issue that I need to address before your lordship. So therefore, my lord, on the first point, कौन सी? वो जो और लाइक कर Now, Lord, so therefore, in my humble submission, I have finished with the point of whether 233(2) includes that second stream.
According to the 233(2) includes both the streams.
Yes,
And the finding of Jurors More,
is
that
completely wrong.
233(2) is exclusively
Yes.
for the members of the bar,
Now, Lord,
is not correct.
correct.
In
Now,
other words, we'll try to understand the argument.
yes,
233, 1 and 2, they speak about, they don't distinguish between the promotion and other things. So therefore, qualification is in 233.
Lordship, yes.
And then 233, one it generally speaks about who is the authority to do it, whether it is promotion or a recruitment or appointment.
Correct, correct.
These are all general.
Right.
Governor in consultation with this. And then second thing, it only specifies the qualification of the lawyer. Therefore, you have to read 1 and 2 together.
Absolutely.
One does not restrict only to the judicial
Agree.
officer, and therefore two does not restrict to the lawyers.
Correct.
They both will have to be written in consonant.
Right, right. That's exactly, Lord, how the two constitutional benches.
Lawyers cannot get into obviously promotion.
Correct.
There's no bar for them to come under that.
Right.
Because there is no express exclusion.
Right, right. Now, Lord, that leads me to the next question, which is, supposing the Constitution provides for these two sources, can by rules, can you exclude one source completely from direct recruitments? And that immediately raises, my lord, the Article 14 question. Now, in this context, please note, my lord, that all the judgments which have dismissed the Article 14 argument base it on their Lord finding of 233(2) itself excludes those in judicial service in direct recruitment, and therefore you're not eligible. Therefore, there's no question of Article 14. None of them has gone to the extent of saying, no, there are two sources, but one can be completely excluded. So the Article 14 question is very, very clear. If there are two sources provided for by the Constitution, according to me, my lord, one, you cannot just shut out one. Then you are doing something contrary to what Volume 5 to PDF 72. It's showing Shetty connection first. It's volume. So therefore, my lord, my submission on this is, if the
Which are, whether the rules framed by the state governments in consultation with the High Court provide for exclusive bar members.
yes, it does, my lord. Your lordship will have a look at volume 4. We have the UP rules. Just have a look at page 415, Rule 5.
Page,
Volume 4, page 415. This is the UP rules, my lord.
UP higher judicial service.
Yes. UP Higher Judicial Service Rules 1975. And if your lordship turns to page 415, Rule 5, under Part 3, recruitment.
Yes.
Sources of recruitment. The recruitment to the service shall be A, by promotion from amongst the civil judges, senior division, on the basis of principle of merit cum seniority and passing a suitability test. B, by promotion strictly on the basis of merit through limited competitive examination of civil judges senior division having not less than 5 years qualifying service, which your lordship has directed to reduce it to 3 years. And C, by direct recruitment from amongst the advocates who have been not less than 7 years practicing as an advocate on as on the last date fixed for the submission of application forms. So direct recruitment only from advocates. For civil judges, only promotion and this limited departmental comparative exam. You are excluded from direct recruitment.
Amounts to reservation.
I'm sorry, my lord.
Amounts to reservation.
Yes, amounts to reservation in favor of the advocates. So now the question is, can such a rule be, my lord, supposing your lordship holds that 233(2) does not exclude civil judges, persons already in the judicial service. In fact, it includes them. Can the rules exclude them completely? That direct recruitment will be only, my lord, of advocates. In my humble submission, no. That would be doing, my lord, violence to the language of the Constitution and the intention of the Constitution makers. The promotion or that limited direct departmental comparative examination is not a substitute, because that, as your lordship has noticed in that
In any
recent
case, both
judgment.
these constitutional bench judgment,
Yes,
they deal with the direct appointment.
yes, correct. They were not promotions. They are not saying, they were both dealing with.
Therefore, they did not say that they are not even qualified. See, if the question of qualification is there, there's no need to discuss that.
Right.
Yeah, that is the issue. The problem is
Your lordship is
that,
right, but
problem is that, we see, by the order of the
ultimately-
court, they
ultimately-
created two channels.
ultimately,
And
my
we
lord,
try to understand the constitutional mandate through that, through those
Correct,
channels.
correct.
That's the
But-
problem.
Not two, three channels.
Three channels, yeah, three channels.
but
Yeah,
my lord,
yeah,
somebody will have to strike down the rule. The rule is excluding us. Once your lordship holds that no, the Constitution permits, then according to me, the answer is very clear. Then the rule is wrong, excluding us completely. Because till the rule is set aside, that rule still remains and still excludes us. Therefore, my lord, that was our prayer in the writ petition, namely set aside this rule which excludes us. That will ultimately have to be allowed. So I'm just very briefly addressing your lordship on that. Now, my lord, I want to show your lordship the Shetty Commission report. Same volume, volume 4.
Till we create the different modes of recruitment,
Yes,
as you rightly said, there's only one way.
yes,
Somebody to be appointed as a district judge. Supposing it comes by promotion, the others will not have any grievance. It can be regulated only under that. Now, earlier what was there, that the district judge is separate appointment. So they said, who are all qualified to be appointed? There is only one mode. So which means, the judges also be eligible. And then those who are lawyers who complete the 5 years, readily become eligible. That's only one matter of recruitment. To that extent, then the other point of there was no issue. Once we created the subcategory, that's the chief said, one through limited competitive examination, one small channel.
your lordship is right.
Then it is the promotion. Then we are trying to understand the mandate of the Article 233 in the light of the factual scenario. That creates a lot of other issues.
Absolutely right, my lord. In fact, that's my case. That what they are saying, one of the arguments that they make is, look, under the rules, 75% of the posts are in any case reserved for civil judges, 50% by promotion, 25% by way of this limited departmental comparative exam, and only 25% are left for lawyers. Therefore, that must be upheld. But that's not putting the cart before the horse. Namely, you are saying that you must look at the rules to interpret the Constitution. That can't be. And my lord, yesterday, for the first time, I found a direct judgment on that subordinate legislation cannot be used to interpret, my lord, a provision of the act. Otherwise, you, by changing the subordinate legislation, you can change the meaning of the act. That can't be. Subordinate legislation is made by, not by parliament, is made by the government, etc. How can the meaning of the act, or in this case, the constitution, change by looking at the rules? Therefore, namely, my lord, if the constitution says that both these streams are eligible for direct recruitment, then you can't exclude one. That has all been done on a misunderstanding of what the constitution says, and, my lord, justified by various courts, including some judgments of our court, including Dheeraj Moore, by thinking that 233(2) actually is a negative. This thing that that if you are a civil judge, then you are not eligible. That's what the article says.
Exclusively reserved for the bar judges.
Yes.
Yes.
Now, I was showing your lordship, my lord, the Shetty Commission report. And if your lordship straight away turns to page 656 of this volume 4, where does it start? Starts at 649. Yeah. The relevant portion starts at 656. And I'll just read some parts of it. Because, my lord, the Shetty Commission came to the conclusion that this kind of thing, that you are not eligible to sit for the direct recruitment, is creating a lot of frustration and a lot of stagnation among civil judges. And this is something that your lordship has recently noted, that the reason why we are getting not very good people for appointment as civil judges is because they feel that they get completely stagnated. I get into the service and then now for 15, 16 years, I will not even become a district judge. Your lordship has noticed, my lord, those.
We have issued a notice in that matter.
Yes, yes. No, so last week your lordship has issued notice, but before that your lordship noticed where your lordship has said that senior division should be the requirement of 5 years and senior division should be reduced to 3 years. Your lordship has noticed in that, my lord, in one part of the judgment, how long it takes to even become a district judge for civil judges. Sometimes in some states up to 15, 16 years.
Right away, I was also telling the Honorable Chief, one of my law clerk back there in my High Court, I persuaded to accept the civil judge unit division. She's a topper. Last time she met me, then she said, I want to resign.
Yeah. Correct.
Where do I end? These are aspirations of the young mind. So,
And
what
this,
extent we can curtail their.
correct. And if your lordship were to hold.
Unfortunately, many of the brilliant
Yes.
candidates who join us with the senior division, they don't even reach up to the principal district judge.
Yeah.
Yes.
They have to retire they get stagnated as district judges for years together.
Correct. And some of them are, I mean, one of these people who.
So we have to look at it not from their point of view also, from the point of view of the institution and the concept of basic structure.
Yeah.
The idea is to give a qualitative service from the judicial officers. If does not facilitate it, then you have to take, it will be a contrary to the constitutional mandate.
Absolutely right. If you tell
You
people
have
that
to
if you are
make
accepting.
the bottom of pristine quality, and then you have to take it forward.
Correct.
But if you make it much weaker, then it will justify the structure and keep going in appeal, revision, further appeal, SLPs.
Absolutely right.
This is the
If your
problem.
lordship were to hold, my lord, that 233(2) permits civil judges to sit directly for this direct recruitment of higher judicial service, it would encourage so many more people to take the civil judges exam, because then they won't feel like once we are in here, it will take us 15, 16 years to become district judges. We are
They
excluded.
will not come. So
Yes,
how do we encourage our juniors to take this examination?
correct.
So he is saying that if you answer that question in their favor,
Yeah.
then it.
That's right.
Come.
Absolutely right, my lord. Because if right now they have the feeling, look, if I take this, I'm stuck. I can't sit for the higher judicial service exam. I can only go by promotion or limited departmental. And sometimes that you becoming eligible for that limited departmental comparative examination comes after, my lord, the date where you can be considered for promotion. And very often it takes about 14, 15 years. Whereas if this was permissible, then within 3 years they become civil judge, another 4 years where they'll have a combined experience of 7 years, at least they can sit for the exam.
So that you are agreeable. So even in the event.
But I am agreeable. I am agreeable, although, my lord, the constitution doesn't say so, but I feel that your lordship can lay down, because after all, there has to be a certain amount of experience that a person must possess for being. If you must have 7 years as a lawyer, you must also have 7 years as a civil judge, or combined experience of lawyer plus civil judge.
What about age? So then, if for direct district judges, age is prescribed as 35, then if you are permitted to join it prior to that, it will not be discriminatory towards the members of the bar.
It's a gender restriction.
It should be so long as.
Goes along with, see now, even for the lawyers also, age restriction is there.
That's what.
That gender restriction will be there. Age has to be.
It is another requirement. Age is another requirement.
Civil judges, I don't think there's an Article 14 issue. And my lord, that is something that your lordship may, consider whether it should be lowered for both the categories, namely for lawyers also and for civil judges also, as to whether they would be more encouraged to take civil judgeship or even the higher judicial service exam if it was less.
They put a state barrier because they cannot go outside the state. Only 5 minutes.
I was showing you, Lordship, my lord, the Shetty Commission recommendations. They realized that, look, this is a huge point of frustration for civil judges, and recommended that they should be permitted to take the higher judicial service exam, because till then, my lord, it had become a sort of a established norm that they were excluded. So Shetty Commission said this, but unfortunately, my lord, when the Shetty Commission came to court in that All India Judicial Services, that judgment, this part was neither noticed nor rejected nor accepted. So I'm just showing to you, Lordship, my lord, at page 656, conclusion, just below Article 233(2), about middle of the page, conclusion, 11.50. 656 of volume 4. Volume 4 has all those historical documents, my lord. We have given our anxious consideration to the views and comments expressed by the respondents to our questions 8.3 and 8.4. The majority of the high courts and the service associations, barring a couple of them, are for giving an opportunity to the service judges for direct recruitment of district judges. Even some of the governments are in favor of such a move. The reasons given in support of the proposal are that it would promote efficiency, improve discipline in judicial service, and make the officers to work more efficiently, diligently, and sincerely. We are highly impressed by the reasons given by the High Courts of Allahabad, Bombay, Punjab and Haryana, and the All India Judges Association. If meritorious young blood should be introduced in the mixed cadre, there is no reason why merited serving judges should be excluded from consideration for direct recruitment. In such selection, the High Court will have an opportunity to assess their merit, the merit of serving judges as against the merits of the competent advocates. The Bombay High Court has rightly observed that the High Court in such selection will have an added advantage of assessing the service judges on the basis of their work and confidential records. So, and the next page also, my lords, up to about 11.58 are the relevant parts of the Shetty Commission report. I know, my lord, I'm running out of time. That's why I'm just.
No, you tell us what are the paragraphs which are relevant to that.
Up to, my lord, from 11.50 up to 11.58.
We have eaten into your time in between.
No, no, Lord. That is part of my time,
You have
Lord.
to finish it in 3 days. no?
That is always part of the lawyer's time. Your lordship's questions are most welcome, my lord. That helps us to.
Unless your lordship,
Yeah, we have it.
it's not fruitful. I was saying,
Mostly what everybody would be doing is saying that we will not repeat anything but repeating the same argument.
we will try not to do it.
Or you have an
Lord.
experience, I have an experience of more than 6 years now. so.
Which of the interpretation of the hotel.
Lord, just one judgment I want your lordship to see. That is Hotel Balaji. Where is that?
Balaji.
Hmm? Volume 7.
This 233A and B,
Yes,
1 and 2.
yes.
You mean to say in 2, if a person is having 7 years of service, then he's eligible.
No. According to him, he should have a combined experience of 7 years.
7 years service or combined experience as a lawyer and a service.
Although, my
Or,
lord,
or if he's a lawyer, then minimum 7 years as a lawyer.
So these 3 propositions.
yeah,
you have.
correct. Although, my lord,
Please stop there. Because under 217 also,
yes,
10 years service,
yes,
10 years as a lawyer,
yes.
and suppose somebody is a judge for 9 years and he resigns. He's a lawyer, he's a lawyer for 1 year, then the 9 years experience has to be included.
Correct. That explanation double A.
Yes, sir.
Absolutely right, my lord.
Double A.
Yes, explanation double A.
Even if he is a lawyer even for a day,
Yeah, so
and if completes 10 years, then he's eligible.
correct. Absolutely right. Of course, my lord, I'm not saying that this 7 years of either lawyer or lawyer.
No,
plus judge-
my learned brother is
I know, my lord, I know.
saying that if a judicial
That-
officer,
that
so
should come-
we have had instances of persons reaching up to this code also, where judicial officers and then also district judge and then high court judge. So he said that for being appointed as a high court judge, if you are in service for 9 years and then only a lawyer for 1 year, then your 9 years experience gets counted as a 10 years lawyer. So why not that analogy here?
Right. Now, my lord, I was just explaining that, and I'm grateful for your lordship's observation, but I'm just saying that requirement of 7 years as civil judge would not come from the constitution. If your lordship just comes back to 233, that would come from your lordship's, my lord, Article 142 powers, namely, as your lordship has done recently, that lay down that.
So it can be, by applying the principle of harmonious constitution, also it can be said
Although-
that if the constitution requires a 7 years experience as a lawyer,
Correct.
then by same analogy, a person who is not having 7 years combined experience as
I
a lawyer
agree.
or.
I agree, my lord, but that explanation
There's a
double A.
lot of debate on 142 now.
That explanation double A would be relevant only if the article had actually said that even as civil judge, you need to have 7 years. So therefore, there the hybrid, etc., would come into play. But, my lord, 233 doesn't say anything about the experience as a civil judge. It only says
That we will have to read.
that your lordship can read into it. Yes, whether 142 or whether lordship reads
Subject to
it.
hearing them, otherwise they will say that.
हाँ, now just कहाँ है वो होटल वाले?
So you see,
इसमें मेरे केस लॉ में है ना? Lord, just one judgment I want to read on the aspect of that you can't use subordinate legislation to interpret the.
is there any judgment necessary on that proposition?
No, quite, but your lordship must pronounce that judgment because, my lord, I'll tell your lordship why. I have been using this argument in several cases because it's an obvious proposition in my mind. Namely, how can you use the rule to interpret a provision of an act?
The rules and the statute.
Supposing there is no
will
conflict.
go away.
Supposing
There is a conflict between a constitutional provision and the statutory provision.
that's Kelson's pure theory of law, but that's a slightly different, my lord. Supposing there is no conflict, can you use a rule to say this is what the act means? And according to me, you can't for the simple reason that otherwise by amending the rule, Can you say that, all right, now the act means something different? The act, what it means will have to be seen on its own. The rule can't change the meaning of the act. And I had been, my lord,
Yes, please tell us.
volume 7, page 4240. Volume 57, no? Sorry, volume 57, Roman 57, page 4240. This is 1993, supplement 4 SCC 536. After having looked for it for several years, my lord, one of my juniors found it yesterday.
He deserves compliment.
What is the, what is the law laid down?
The law laid down is, my lord, if your lordship has para 17 and then 31 and 32. 4257 is para 17.
Hotel Balaji and others.
Yes. Because very often, my lord, in high courts, we find judges using rules to interpret provisions of the act. It's a reasonably common, my lord, mistake. That's why I'm saying that your lordship must at least lay down in this that no, you can't do that. So now, my lord, Placetum F on page 17.
4257.
4257.
Para 17.
That's the submission and then 2 paragraphs, my lord, of the finding.
At page
4257, my lord, is the submission. And the finding is at page
4262.
4262.
Para 31. At the
Paras 31 and 32.
read कर लो यार.
Yeah, I'll just read, my lord,
one way.
the finding. Go to 62
4262.
and 31.
31.
Yes.
If your lordship comes to page 4262, para 31, and I'll start at Placetum E.
Four two six two.
Yes,
Placetum E.
para 31.
The argument raises.
This argument raises in turn the question, how far is it permissible to refer to the rules made under an act while judging the legislative competence of a legislature to enact the particular provision? The necessity and significance of the delegated legislation is well accepted and needs no elaboration at our hands. Even so, it is well to remind ourselves that rules represent subordinate legislation. They cannot travel beyond the purview of the act. Where the act says that the rules on being made shall be deemed as if enacted in this act, the position may be different. It is not necessary to express any definite opinion in this aspect for the purpose of this case. But where the act does not say so, the rules do not become a part of the act. Sri Mehta relies upon the following statement of law in Halsbury's Laws of England, 3rd edition at page 401. Consideration of subordinate legislation as aid to construction. Where a statute provides that subordinate legislation made under it is to have effect as if enacted in the statute, such legislation may be referred to for the purpose of construing a provision in the statute itself. Where a statute does not contain a provision and does not confer any power to modify the application of the statute by subordinate legislation, it is clear that subordinate legislation made under the statute cannot alter or vary the meaning of the statute itself, where it is unambiguous, and it is doubtful whether such legislation can be referred to for the purpose of construing an expression in the statute, even if the meaning of the expression is ambiguous. He says that this statement of law has been referred to with approval by Justice Hegde in his opinion in J.K. Steel Limited versus Union of India. Though in the opinion of Justice Hegde is a dissenting one, he submits the majority is not held to the contrary on this aspect. He also relies upon English decisions referred to in the opinion of Justice Hegde and points out that no decision of this court has expressed any opinion on the subject, a fact noted by Justice Hegde. He commends the view taken by Justice Hegde for our acceptance. Shri Mehta points out that further Section 86, which confers the rule-making power upon the government, does not say that the rules when made shall be treated as if enacted in the Act. Being a rule made by the government, he says, Rule 42E can be deleted, amended, modified at any time. In such situation, the legislative competence of a legislature to enact a particular provision in the Act cannot be made to depend upon the rule or rules, as the case may be, obtaining at a given point of time, he submits. We are inclined to agree with learned counsel. His submission appears to represent the correct principle in matters where the legislative competence of a legislature. So, of course, this was about legislative competence, but even when you are construing a provision.
You can't if you are construing a statutory provision,
Right.
it can't be construed on a both. So this was with regard to whether the rules could be read as a statute.
Yes.
So for that, if there is a substantive provision in the statute that the rules will have to be read as a part of a statute, then it's a different matter.
Right.
If
Absolutely.
the statute does not provide for that, then the rules are always subordinate to the
Correct.
statute.
And any change in the rules can't change the meaning of the Act.
And statute would always be subordinate to the Constitution.
Correct.
So you can't read a statutory provision to interpret a constitutional provision.
Right. Absolutely right. And so, and here they are trying to read rules to interpret a constitutional provision. I mean, two steps high.
We have to
I'm
put-
very grateful to Lordship.
Thank you. In spite of our eating up on your time, you completed it.
Lord, there was some, I would have distinguished their judgments, but Lord, since for paucity of time, according to me, Lord, they are totally contrary to those two judgments, totally contrary.
In any case, there are only 2 5 judges, Constitution bench judges.
That's right.
The other, if there are 2 or 3 judges judgments, they may not bind us.
Absolutely right. Absolutely right.
Dhiraj Mori is also 3.
Yes.
Yes, Mr. Datta.
My submissions are in a very narrow scope. If your Lordship sees my
You
written
are in which
submission.
number?
Yes, I'm in SLP 3076.
You can give the item number.
501.28.
0.28.
Yes, my lord, my submissions are very limited.
You can just tell us, you are a
Yes, in simple
judicial
terms,
officer.
I was a lawyer. I practiced for 9 years. Then, my lord, I joined the judicial service.
Practice for 9 years.
I practiced, my lordship, just take my written submissions. The chart is there. It'll be easier, madam. Take my written submissions. Starts at page 32.
Written submission. Mr. Bhushan started his argument with your submission.
Pardon me?
So Bhushan started your argument with your submissions because your submissions only contain all the 4
Yes.
questions.
In fact, I'm going to request your lordship that I'm asking 2 more questions to be taken because the focus of my submissions is that para 45 of Dheeraj More requires reconsideration. That is the short submission I'm making. Because in para 45 of Dheeraj More, they've added 3 new conditions into Article 233(2), which I'm submitting requires reconsideration at your lordship's hands. That's the
But
problem.
if we answer question number 4
Yes.
in the affirmative,
Lord, what my submission is, but still, even if your lordship answers question number 4, the para 45 will still be a law under Article 141, because what the court has said, 7 years means 7 years continuous up to the cutoff date. So, Lord, there is a question as to whether what's the meaning of the word immediate past. So ultimately what Dheeraj More says is, suppose tomorrow I appear, I'm going to apply for the post of a district judge, I write the exam. Then on the cutoff date, that is the date of the application, I should be 7 years in continuous service on the date of my application. It goes on to say I should also be 7 years on my date of appointment. That's the problem.
on the rate of appointment also.
Also. So that is the problem.
So suppose if you appear for 2 examinations,
Yes,
the district judge and the civil judge,
yes,
you get selected as a junior division. So that result comes first
yes,
and you join that.
yes.
And thereafter, when you are also selected for the district judge, the result comes 6 months thereafter.
According to that, I'll be disqualified. Because I must be 7 years on the date of appointment also.
Matter is there.
That is the fact.
Kerala matter is there on this surface.
Facts in Vijay Kumar Mishra.
Because-
What your lordships have recounted are the facts in Vijay Kumar Mishra. which was answered in favor of the petitioners by saying that you can resign and join, because they distincted between the process of selection and appointment.
Because the qualification will have to be as on the date of the application.
Application, exactly. That's my point. It did not go. And number one. And secondly,
Lordship rightly said, my lord, if question 4 is answered in our favor, that combined,
Yes.
then he also sails through.
Well, then we were not, because that may open up Pandora's box. Suppose like Nandi Brother point was, suppose if you have a 7 years experience, then you give up your practice for 10 years and do something that you go to films or
no, for example, no, Lordship,
or
yes,
some
sabbatical.
open a restaurant or something.
Yes.
And then after 10 years, you say that I'm coming back to the practice and now count that the 7 years experience
Lord,
of 10 years back.
no, suppose I practice for 10 years and then I join, say, I become a lecturer in a college. And then I decide to write the exam. What is the bar? Number one. Number two.
But then I say, bar would come because you disconnect with the practice.
legal process.
Say, you
No,
can't
no.
just go, maybe connected with the institution, connected with something.
That's the point, Lordship.
Technical officer, that's all that you
No,
can't.
what my submission
We can understand if you.
If you practice as a lawyer.
If you are a public prosecutor
Yeah.
or an additional public prosecutor.
That is Deepak Agarwal's case. Public prosecutors. No, what I'm submitting is one submission.
Or what, for that matter, a law officer. Law officer, so continuing with your legal profession.
No,
But
my
if
submission, once I finish what I'm proposing for saying is this. Once on the facts of my case, my lord, what they say is, on the date of your appointment, you had not practiced for 7 years. I had practiced for 10 years, then I became a judge for 4 years. Again, I practiced for 5 years.
That's a different issue.
That's the problem.
That will cover what we
If
did.
we answer question number 4 in the affirmative,
Yes, yes.
then you will stand concluded.
But my other question is this. As my lords mentioned, ultimately the aim is to get the best possible pool for selection. Get in terms of quantity, you'll get the quality also. If you get a larger pool of consideration, you may get a better quality. What I'm putting to your lordship is this. As far as my client's facts are concerned, if your lordship accepts me, it sails through, no problem. But 2 points are there. Whether Dheeraj Moore is right in saying that the 7 years should be continuous on the cutoff date on date of appointment. That's one.
It's very clear. I think the
It's a date of appointment, the date of application.
Nobody can say that's appointment.
So lordship will just
Unless
para 45.
Because it is so there.
Exactly. No, if your lordship, then I will save time. The other larger question I'm saying is this, my lord. Suppose, my lord, please see para 45. Please see para 45 first.
Yes.
Straight away at page 37 of my submissions.
Sir.
You're reading
Dheeraj Moore. And the same thing is reiterated in the conclusion. So I'll just read para 45. In view of the aforesaid discussion, we are of the opinion. Para 45, reproduced at page 37 of my written submissions. Para 5.1.
Yes.
May I read, my lord? Lordship's got all of it. In view of the aforesaid discussion, we are of the opinion that for direct recruitment as district judge, as against the quota fixed for the advocate/pleaders, incumbent has to be practicing advocate and must be in practice as on the cutoff date and at the time of appointment, and he must not be in judicial service or other services of the union or state. Full stop.
If we answer for this goes.
Yes, for constituting, correct. That goes. I'm only underlying the portion from my client's perspective, which is I'm just putting. But since you're also in the constitution bench, we're getting a golden opportunity of completely interpreting 233, 1 and 2, my lord. So that my humble request is let us consider all the ramifications so that this guidelines for the future also. Because after this, then if your lordship wants laid down the law, then it's completely settled. There is no other judgment of 233 except the old Raghuvar Dayal and Chandramohan. For constituting experience of 7 years practice as an advocate, experience obtained in judicial service cannot be equated combined, and advocate pleader should be in practice. Now, this is the problem. Should be in practice for the immediate past for 7 years and must be in practice while applying on the cutoff date fixed under the rules and should be in practice.
Answer for in the affordability. This
Correct. So that date of appointment will go.
Totally go to a watch away.
On merit, we are with you, as my brother has pointed out, 217.
Yes.
That takes it. For a lawyer, services rendered as judicial officer can be counted even for constitutional court.
Yes, yes.
And then the absence of any rule, any mandate under Article 233, it goes without saying.
So, my lord, if Lordship sees the box, the facts are given, I'm clearly coming
Vice
with.
versa will be a problem.
Yes, exactly. My lord, I'm also canvassing a larger problem because I'm just looking at this way, my lord. Today, my lord, the service conditions are very attractive for a district judge. The salaries are good. The service conditions are quite attractive than what it was when I was a junior. Now, my submission is this. The 233 says 7 years. Why 7 years? Because they want to fix a legislative period of maturity. For High Court, they say 10 years. For this thing, they say 7 years. So that doesn't mean at 7 years you can become. That's only eligibility. They say that till you are 7 years, you're not even considered to be eligible to be a district judge. And for Munsif, your lordship had put 3 years before. All those questions are there, whether they could go straight from the law college or they must serve 3 years.
Answered that.
Now you answered that question. So now there's a gradation. For the lower level, 3 years, district judge 7 years, High Court 10 years. This is the mantra. Now my only question is this. What happens to a case? Suppose I practice for 10 years. Now, suppose there's a break. Suppose I practice for 3 years. For various reasons, I may decide for financial reasons to take up a job. Because I know in my own case, when I was in Madras, there's a lawyer who practiced for 2 years in financial difficulty. He joined a company for 11 years, then resigned, and because he had saved money, and then practiced for the next 35 years as a successful criminal lawyer. Now, suppose he's practiced for 3 years, taken up a job for 9 years for financial reasons. Again, he comes and practices for 6 years.
Let us not
I'm
take-
saying don't 7 years continuous. Please consider it. I'll tell Lordship why. Because 7 years continuous not necessarily should be because the Constitution doesn't say so. It says practice for 7 years. What is the magic or what is the thing of 7 years continuous?
That will be, going
Difficult for us to
to
accept.
be difficult for us.
It has been rightly interpreted that Shetty.
He has been in practice. Please see 233. I'll just.
Proceeding that 7 years, that's all.
But no, should it be continuous for 7 years? Should it be continuous? No, but I'll tell Lordship why. In Article 222, when transfer came in Sankal Chand Seth's case, the question was whether the transfer could be without the judge's consent. That was Mr. Sirwa's argument. Yeah.
We don't go by your factual scenario in your case. What the argument you are making is very difficult for us to accept. For example, say what if somebody is there not practicing for 6 years and 11 months, and 1 month is practicing. We wanted that earlier practicing period to be taken.
No, I'm not taking that. I'm not.
Continuous only.
No, the point is that will come in the question of suitability.
There's a disconnect. We must reconnect and be there for a reasonable time. And then if you say that, take into past function as a lawyer.
What I'm asking is question is, suppose I practice for 10 years. Suppose I practice for 10 years. I've completed 10 years. 10 years continuous practice I've completed. And then I join a particular service, say the law, and there I can always apply lordship because now the question is, should I be practicing advocate on the date of my application? My point is not necessary so.
On the date of application, you have to be.
Pardon me?
On the date of application, you have to be a practicing lawyer. Either a practice, if you hold in your favor, either a practicing lawyer or in service of a union or a state.
Has been a practicing lawyer means you have to continuous this state. That's clear. See,
On the date of application, you have to be.
No,
Maybe not on the date of appointment.
yes, it's split. Split should
No,
not.
I'm not talking about split. I'm saying suppose I work for 10 years. Now, my lord, the point is a person as jurist, he can become a Supreme Court judge. I'm just asking myself the question. Please say Article 233.
Don't equate a jurist with.
No. Unfortunately, my lord,
Unfortunately, somebody has been able to make it so far from that category.
I realized that 42nd Amendment dropped jurists in the High Court position. It was there for High Court and Supreme Court.
Earlier, High Court also it was.
No, not then.
So, suppose, for example, if somebody practices for 3 years and then thereafter runs a bar for 10 years
Yeah.
and thereafter practices for 1 year,
No.
should that be taken into consideration as the entire experience at the bar?
No, I'll tell Lordship, Lord. Lord, it's a very good example, Lord. He's continuously in the bar. No, Lord, what I'm submitting is, take a Lordship. No, Lordship will kindly see. No, please see, 233.
Too hazardous.
He'll have.
No. What I'm submitting is two questions, my lord. Suppose he has finished 7 years completely. He then takes
Yeah,
up a
yeah,
job,
you're right.
and then he resigns, and then on the
Uh,
date of
We
application.
don't
No,
want,
they-
we don't
they-
want
they-
to accept.
they need to be still covered by 4.
Yes.
That's enough.
If 4 is answering the affirmative,
Hmm.
then it will be covered by 4. 3 years practice, 3 years in service, again 2 years at the bar.
Judicial service.
Judicial or public prosecutor or
That's right.
I'll put it this way, my
law
lord.
officer or something,
No, no,
something to do with law.
Yes.
No, I'll put it this way. Suppose a person is in practice for 10 years. He joins a tribunal. Because now today the whole difficulty in tribunal, you can't be more than 4 years. No.
It's almost a judicial.
No, Article 217 AA says judicial service is different, the tribunal service is different. It's not a judicial service. See, what I'm submitting is, if a person has finished.
Take a hard case and then later on law.
No. Because what your lordship lays on principle should apply universally. And only a hard case will test the principle. In terms of physics, a proposition will be correct only if it tested on a hard case. That's why I'm saying. Lordship will just see 233 and I'll not go because my time is up just to. Because
There are 12 more minutes. 12 more minutes.
I'll try to finish in before that. Tell lordship why. Please consider 233, madam.
Yes. Yes.
233.2 I'm on.
Yes.
I'm saying whether we can add the adjective continuous. And that was added by Deepak Agarwal, by Justice Lodha, where he said, it's in the present perfect continuous tense. My submission is there is no present perfect continuous tense. I'm coming to that. Please kindly see para 233.2. A person not already in service of the union or the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. So if a person has finished 7 years appointment, now two questions are there. Whether 7 years should be unbroken, number one, or it could be that he practices for 3-4 years. For various reasons, he has to leave the practice, he works, again he resigns, again he practices for 7 years or 10 years. What happens?
Or you have not been a lawyer for 7 years.
If you are not connected with law for
In the aggregate.
Has been, you see, past you can't bring it into the present. That's a
No,
difficulty.
no, he has been a lawyer.
Honorable Chief said, on the date of the application, you should have put in continuous 7 years and on that day you should be a lawyer. That's all.
either a lawyer or a member of the service.
Malad, I'm grateful. Lordship is now clear. Let's not go to date of appointment. Let's fix to date of appointment.
Date of publication.
Date of application.
Like the example we gave.
I don't think they can
Somebody,
put that also.
Yes.
if 2 applications are held, 2
Yeah.
selections are held simultaneously, the JMFC and one appears for both. JMFC comes for earlier, he joins.
Lordship will
And
just.
thereafter, after 1 year.
Correct. Unjust.
That can't be to the detriment of a person.
And the person who applied, he can't indefinitely wait till the
Wait
appointment.
till-
Exactly. I'm only requesting my lord to say that 7 years, it need not be non-stop for a person.
No, that, we are saying combined. We are saying, if we answer in the positive,
Yes.
we say combined 7 years experience. So it
That's
could be initial 2 years as a lawyer,
Yes.
then 3 years as in service. You resign from the service, again you are immediately start practicing.
Ah.
Then you come, have 2 years of
5 years.
practice.
3 plus 5, 8 years.
Plus 2.
Yes.
It makes out 7.
Yes, enough. So lordship will say that it's in the aggregate, not continuous, because what? No, I'm requesting your lordship. No, because, no, kindly.
Yeah, if there is a disconnect from the legal,
That
No.
would be very dangerous.
No, lordship will kindly see, not judicial service. He could be a public prosecutor.
that is,
Number one.
public prosecutor, even for that matter, a law officer with, say, public.
Suppose he's working as a legal manager in a company, corporation. Suppose he works
He
in.
will not come. He is an employee that he can't not come.
All right. Lordship will take, suppose a tribunal member, please come to 217 AA, 217.1. So now, Lord, just to clarify, since we're laying down the rules, it can be aggregate 3 plus 4 and a break can be towards the judicial service. I'm only submitting, suppose it's a tribunal service, kindly come to 217 AA.
Yes, please.
217, explanation. Now in computing the period, see, kindly come to 217, explanation AA. In computing the period during which a person has been an advocate of a high court, they shall be included any period during which the person has held judicial office or the office of a member of a tribunal or any post under union or state requiring special knowledge of law after he became an advocate. So now, Mala, today when there are so many tribunals And the
So
appointment is of 4 years.
Tribunals we may include.
No problem.
Yeah.
See, it says member of the
Yeah,
tribunal.
tribunals or even a
So-
post
no, Manoj,
requiring
that was-
knowledge of law.
I'm not
If
just
we-
mentioning judicial service. I'm saying extended to tribunals also.
But, article
no.
itself says member of the tribunal.
It is normally,
217AA, it's not said in 233.
if a person.
Yeah, that's what I'm saying. So according to your lordship, my lord, suppose as a lawyer, for various reasons, I take up a job as a law officer in a company, as a legal man, that will not be qualified. In a public sector undertaking also, no. I take it that way.
Yes, but if it is in union, by giving an interpretation to AA,
Yes,
we can include a person
as a
who is
tribunal member.
in service under a union or a state requiring special knowledge of law, like under secretary, law department.
Or this legal remembrance, like
Legal
V.S.
remembrance.
Deshpande.
We have had,
No, just V.S. Deshpande was
no.
also legal remembrance, sir.
V.S. Deshpande and Justice Vaze,
Yes.
he was a law secretary in the Union of India, law secretary or additional law secretary. From there, he came to Bombay as the judge of the High Court.
Yeah, no. Yes,
So we can,
V.V. Vaze.
by giving meaning to expression AA,
Yes,
we can include this category of candidates.
yes. Sorry, madam.
But that will create complications. A
Pardon?
person is in JAG branch, Judge and Advocate General branch, whether he'll be included or not.
Yes, he will be included because he will be in the service of Union.
You know.
He will be in the service of Union. If,
It could be in the judicial, yeah, your lordship is right, Army, JAG,
It can be
judicial,
applied for a
JAG
constitutional
branch.
post. Whether when it can be applied for a constitutional post.
Why not, by logic, what do you
Yes, in the same logic, it can't be otherwise.
but not beyond this. Otherwise, then the combined experience of 2 bars.
Yes, so, no, lordship will just see what portion I wanted, so this portion of para 45, so that second point is correct, the earlier point, lordship will just take.
No, if we hold that the experience in any of the categories provided in AA
Yes,
would also be included,
yes,
then it will cover
that will
everything.
solve the problem. And lordship will kindly see, your lordship also to clarify that practice should be immediate pass for 7 may not be necessary, continuous for 7 years may not be necessary. If there is a break,
No,
break in judicial service.
break on account of any of
Yes,
the services.
exactly, because in Deepak Agarwal, para 102, they say, your service of 7 years should be unbroken before on the date of application, which may not be correct is my humble submission. Kindly come to Deepak Agarwal page, para 102. And that's what is followed by Dheeraj More. Please come to Deepak Agarwal, one page.
No, we will say that, say, as Honorable Chief said, it will become unbroken. If you add with both these two, it will become unbroken only. It will not break. Whether you work as a lawyer or a judicial service, it will not break.
Whether work as a lawyer
Continue in
plus
service.
217 AA categories.
That's correct. Only to that category.
Only to that.
That category, yes.
Yes. So lordship, to that extent, 102 of Deepak may have to be overruled. Kindly come to volume 5.2,
Yes.
volume 5.2.
Page 86 of the current complaint.
Okay,
Which
fine.
I've just handed over.
Can I borrow?
Yes, sure. Page 86, you can take this, that's my part. You're okay with that?
Yes, yes.
Deepak Agarwal.
Yes. At page, there was a question of whether public prosecutor, government leaders will also be included. Lordship will just come to Deepak Agarwal. Lordship will see the first page, at page 32 it starts. The question before the court
1 minute.
is set out at page 42. Lordship, page 42, my lord.
Yes.
So Lordship will know what is the controversy at page 42. May I read, my lord? Leave granted, that part,
One more.
page 42.
Page 42.
Yes. Page 42, may I read, my lord? Leave granted. What is the meaning of the expression, the service in Article 233(2) of the Constitution of India? What is meant by advocate or pleader under Article 233(2)? Whether a district attorney, additional district attorney, public prosecutor, assistant advocate general, who is a full-time employee of the government and governed by the and regulated by statutory rules of the state and is appointed by direct recruitment to Public Service Commission is eligible for appointment of district judge under Article 233(2) of the Constitution. These are the questions. And they answer it in the affirmative. But problem, para 102, my lord. I read, my lord, 102 at page 86. As regards, may I read? All lordships have got it?
Yes.
As regards the construction of the expression, if he has been for not less than 7 years as an advocate in Article 233(2) of the Constitution, we think Mr. So-and-so was right in his submission that this expression means 7 years as an advocate immediately preceding the application and not any 7 years any time in the past. This is clear by the use of has been. The
So must
present,
be hold that combined experience of
yes,
a lawyer and a judicial officer and any of those categories
yes.
mentioned in explanation double A.
So he need not be an advocate per se, because this paragraph says in Deepak Agarwal, advocate for continuous 7 years, which may not be correct. In your lordship's formula, advocate plus 217 double A plus I could 3 plus whatever it. That's so this paragraph may not be correct. This has been followed in para 45 of Dheeraj More. So lordship may, because even what the lordship said, present perfect continuous tense is not correct. It's present perfect tense. If you say present perfect continuous, there must be a verb.
Ending in ing.
Yeah, yeah, ing. I and ing. So we check Ren and Martin after a long time, my lord. I'm sorry to say, my lord, my children, there's no grammar in CBSE now.
They don't understand what is Ren and Martin.
No, there's no grammar in the syllabus now. Yes, not unknown, yes. So, my lord, so my submission is my client's facts comes squarely to the point. She has finished 9 years, 4 years judicial service, and again 5 years. Therefore, selection should be. She was discontinued on the basis of para
But
45
we
of
won't be
the.
deciding the question, we won't be deciding the individual.
Yes. So, lordship, last 2 questions which I have raised, that lordship see if whether what lordship wants to deal with them in my written submissions. Just see the last page. Well, I have done. Just.
State of application.
Page 39 of my written submission. My humble request is page 39, whether 7 years in Article 233(2) means 7 years continuous. Lordship may say it is 7 plus judicial, 3 plus judicial.
Yes.
And the cutoff date should be taken as date of application. Those questions Lordship may add and answer them also. Those 2 questions can be
Not
added.
necessary to add in our discussion, we'll.
No, I leave it to you. For clarity for future, it will be obliged. I've also finished on time.
Because it's not the taxation matter.
Can I have my compiler?
Sorry.
That compiler.
Yeah, sorry.
Sorry.
We'll
Yes, I will.
we'll keep us awake.
Yeah. I will actually finish within my time because my work is much lightened because I am in the same category as Mr. Datar's client. But there is just one aspect I want to highlight, taking off from where he has left. May it please.
Yes, Mr. Patel.
Please have my written submission. I am appearing in item 501.16. Review in writ petition 414. 501.16.
One minute. Number?
501, everybody is in 501, but it's 0.16.
Fine. How many matters are there?
There are total 31, but they're all seeking review of Dheeraj More. So basically, my lord, these are all people who had applied, who got interim orders and undertook the process, but ultimately their writs got dismissed. So they lost. Now, my client, my lord, I'll just tell your lordships in a nutshell. Actually, if your lordship answers the fourth question, then all of us on this side are covered anyway. But there is just one proposition I want to put before your lordships of what the law, how it was understood and why we were debarred and why, according to us, that law was not correct interpretation of the constitutional provision. Now, my client, my lord, he joins practice, he's enrolled in the year 2000. My list, my written submission, my lord, para 2, if your lordship will have the very first page quickly, just to highlight the stagnation, my lord. Sandeep Kumar, my lord, he's enrolled with the Bar Council of Uttar Pradesh in the year 2000. He enters it should be Uttarakhand, my lord. He enters the Uttarakhand Judicial Service as a civil judge junior division in March 2009. He is promoted senior division in April 15. And from May 25, he's a chief judicial magistrate, but he's still serving after all these years in the same position. He applied, my lord, serial number 3I. He applied in pursuance to the advertisement of May 2016. He was not allowed to compete. He filed this writ petition under Article 32, 414 of 2016. And by interim order of 15 July 2016, your lordship allowed him to participate in the process of selection. As per his knowledge, my lord, what is commonly understood there and known, he was second in the overall merit. Doesn't matter. He lost the petition and therefore he lost out. Now, my lord, why were people like me? My case.
You are also part of Dheeraj More.
Yes, we were part of Dheeraj More. My case is that I have 7 years prior to being appointed as a civil judge. I say that I do not want any benefit of my period as a civil judge towards my appointment as an additional district judge by way of direct recruitment. I further say I am willing to meet all conditions of eligibility which are prescribed in the advertisement, age, educational qualifications, etc. I am only being excluded from consideration on an interpretation of the expression has been, which occurs in Article 322, has been 233, has been an advocate for 7 years, is interpreted in para 102 of the judgment in Deepak Agarwal, which Mr. Datar read to mean it is a situation which should be continuing in presenti on the date of the application. And it should remain continuing up to the date
when you actually seek appointment and are appointed. And because a person who joins the judicial service is not continuing as an advocate on that date, therefore he is rendered ineligible. Now, just kindly see that expression, my lord, how it appears, and I will straight away take your lordships. In fact, Rameshwar Dayal also considered this, and what Rameshwar Dayal observed, I was at that point when it was read, not here, but I'm told my lord, the Chief Justice had pointed out that para, that it's an organic document which needs to be considered, and does not need a narrow construction. And that it refers to a judgment of the Allahabad High Court, which exactly says what we are proposing. Now, again, I sound a caveat by saying, if your lordship answers question 4 in favor of the view expressed by my learned friend, Mr. Bhushan, my lord, then of course we are all eligible. Then there is no problem. But equally, just kindly see, my lord, the Article 233 subclause 2. A person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Has been is interpreted to mean a continuing process, a situation which had existed and is still continuing. Our submission is, has been is not capable of that interpretation. Has been, unless it is followed by a participle, which is a verb ending in ing, it refers to a situation which has happened in the past, but may not necessarily be continuing as at present. In contradiction to the use of the expression is. To give your lordships a homely example, in so many statutes which provide for former judges to be appointed in tribunals and commissions, the expression used is has been a judge of the High Court, has been a judge of the Supreme Court. Some, of course, use is and has been. Now, if the interpretation which is given here is accepted, then it can only mean a person who is a sitting judge, which is not actually what it has been understood to mean and does mean, and what it should mean. Now, my lord, I will straight away go to Rameshwar Dayal, my lord, where this argument was raised for the first time and what the court had to say. I have reproduced that part in my written submission, my lord. If your lordship will have page 2 of my submission. Para 3, the judgment is also there, but the relevant part I have reproduced because there is something there which I just see page 2, para 3A. In my lord, sir. It's I gave a hard copy, my lord. Otherwise, it is 4579. But kindly take the hard copy. It's much better. I have.
Submissions of.
I have one more. Your lordship.
Yes.
Yes. In paragraph 8,
Yes.
Page 2, judicial precedents governing the issue,
Yes.
page 8, para 8.
Yes.
Secondly, he has submitted that by reason of the use of the present perfect tense has been in clause 2 of Article 233,
Yes.
the rules of grammar require that the person eligible for appointment must not only have been an advocate or pleader before, but must be an advocate or pleader at the time he is appointed to the office of district judge. Now, this is dealt with in only one paragraph, and that relevant paragraph I have quoted. It is perhaps necessary to add that we must not be understood to have decided that the expression has been must always mean what learned counsel for the appellant says it means. According to the strict rules of grammar, it may be seriously questioned if an organic constitution must be so narrowly interpreted, and the learned Additional Solicitor General has drawn our attention to other articles of the Constitution like Article 5C, where in the context, the expression has a different meaning. Our attention has also been drawn to the decision of the Allahabad High Court in Mubarak Mazdoor, where a different meaning was given to a similar expression occurring in the proviso to subsection 3 of section 86 of the Representation of People Act 1951. We consider it unnecessary to pursue this matter further because the respondents are now considering continued to be advocates of the Punjab High Court when they were appointed as district judges and they had a standing of more than 7 years when so appointed. They were clearly eligible for appointment under clause 2 of article 233 of the Constitution. Now, my lord, so therefore they don't answer it finally. They refer to Mubarak Mazdoor. Now, Mubarak Mazdoor, my lord, I have quoted, attached at internal page, after para 16, page 16, the next judgment. It has gone somewhere else. It's 4594, but it's just after page 16, the written submission. In this compilation itself, if your lordship will have, just have one paragraph of that judgment with me, my lord. Para 3, para 2 and 3. It is here with the written submission. Yes, yes. All right, page 4.
That is not necessary at all. We'll tell you why.
I quite see it.
We'll tell you why.
Yes.
You were judge, working as a judge now, as of now.
Correct.
Judge.
Correct.
So obviously you're not a lawyer as of now.
Correct.
What we are trying to tell you is that this subsection 2 of 233 only speaks about lawyer. How far that principle can be imported into by considering other things is a different issue. Anyway, that qualification is not for you, but in any case, because considering the larger interest we are trying to, at best, they can import into that. Therefore, it's not necessary at all.
All right. I quite
Yes,
see
sir,
that.
that's what it is.
I quite see that. Very quickly, then, therefore, may I tell your lordships. Now, what happened
Once you are not a lawyer, there is no need for this.
I'll just tell your lordship then how the law has developed over the years, my lord, so that your lordship has that perspective also. So, Rameshwar, actually, if I read Mubarak Mazdoor,
Yes.
the clause which was being interpreted was that if the election commission considered it expedient so to do, it may appoint a person who has been a judge of the High Court as a member of the tribunal. That is 4595. This was the expression under interpretation. It was argued has been means in presenti. So because whom person you have appointed is a former judge, he has been a judge, therefore his appointment is bad. That argument is rejected by saying that the has been when not followed by a participle in the present perfect tense and accordingly indicates that state of a being has existed and may not necessarily be continuing. So therefore that was the point. Now what happens as a matter of fact is, my lord, that this in Deepak Agarwal para 102, your lordship, though the issue there was totally different, whether district attorneys, additional district attorneys, public prosecutors are advocates. While concluding that judgment in para 102, your lordship said has been means in presenti. All judges got excluded.
That Mr. Dagar has already argued.
Yes. So then, my lord, after Deepak Agarwal said that, came Vijay Kumar Mishra's judgment, division bench judgment of this court. In Vijay Kumar Mishra, what had happened and exactly what my lord, the Chief Justice had said, Vijay Mishra applied for being appointed as an ADJ. The process started. The process could not conclude over a year. In the meanwhile, he also applied for being appointed as a civil judge. He gets appointed as a civil judge. After his appointment as a civil judge, he is called for interview of ADJ, which he had applied earlier, but the process went on. When he had to seek permission from his present employer. The High Court said first resign, then go for interview. He files a petition in the High Court, which is rejected. He comes here. Your lordships take a view that there is a difference between a process of selection and appointment. The Constitution bar will apply at the stage of appointment, but not at the process of selection. You can apply, you can compete in the process of selection, but if you are appointed, you resign and you join. Now, that judgment then held the field for a short while But subsequently,
And then he was appointed then.
Vinay Mishra was appointed.
He got the benefit.
Yes, he got the benefit of that. No, Vinay Mishra won. Vijay Mishra won. Why? He could not have been selected, but the ratio of law comes in his favor, and it is said you can compete. If you are selected, you resign and you join. So the ratio of law in that judgment is in favor of people like me. But in Dheeraj More, that is specifically overruled by relying on para 102 of Deepak Agarwal. Saying has been means in present time. But in Dheeraj More, there is a very interesting observation in para 76.6, which I do want to read to your lordships, my lord. Just Dheeraj More is at page 99 of my compilation.
Image mode is must be there also in the main compilation.
That's SCR.
Here it is the SEC.
Yes. Now,
Yes.
now kindly see in the concurring judgment, if your lordship wants to make a note, this Vinay Mishra is overruled by the main judgment in Dheeraj More in para 24 and
1 minute, 1 minute.
now if your lordship will see para 24 at page 132, the concluding para. At page 132 of my compilation.
Para?
It's not concluding.
Pardon?
Which paragraph?
Para 24 at
24 is not the concluding statement.
no, it's not concluding.
Yes.
I'm just saying this is where the learned judge considers Vinay Mishra para 24 at page 130
Yes.
and 132. Kindly have after the extract. We find ourselves unable to agree. The concluding I'll show. That is para 47.6. I'll show that also. We find ourselves unable to agree with the proposition laid down in Vijay Kumar Mishra. In our opinion, in-service candidate cannot apply as against the post reserved for advocate pleaders.
No, no, you are reading para 24.
Yes, Manoj. The last conclusion of para 24 at page 132.
Before 25 starts.
Just before 25 starts. Your lordship has the SCC. Yes. We find ourselves unable to agree with the proposition laid down in Vijay Kumar Mishra. In our opinion, in-service candidates cannot apply as against the post reserved for advocate pleader, as he has to be in continuous practice in the past and at the time when he has applied and appointed. Thus, the decision in Vijay Kumar Mishra cannot be said to be laying down the law correctly. Then in conclusions, my lord, in para 47.6 at page 143, again the same thing is reiterated.
1 minute.
Page 1005.
It is at page 143.
Yes.
But significantly, my lord, there is a concurring judgment by Justice But. Now, his conclusions start from page 159. I want to draw your lordship's attention to conclusion 76.6. Para 76 is his conclusions.
Yes.
1 minute, 1 minute.
Yes.
This, what is para?
76.6. Significantly, may I read this because it's important. It's the opening part will say something which is in favor of what I am trying to canvass before your lordships. Significantly, Article 233(2) ex facie does not exclude judicial officers from consideration for appointment to the post of district judge. It's very important. This Justice Bhatt therefore reaches a different conclusion. It, however, equally does not spell out any criteria for such category of candidates. What your lordships had observed also. So his conclusion is in support of what the submission is. But how does he oust us? By have been. That you are not in continuous practice, therefore you are out. Now I'll read this. This does not mean, however, that if they or any of them had 7 years practice in the past, they can be considered eligible, because no one amongst them can be said to answer the description of a candidate who has been for not less than 7 years an advocate or pleader. Per Deepak Agarwal, that is, that the applicant candidate should be an advocate fulfilling the condition of practice on the date of eligibility condition or applying for the post. The sequitur clearly is that a judicial officer is not one who has been for not less than 7 years an advocate or pleader. So this relies on Deepak Agarwal. In my written submissions, my lord, I have dealt with the judgment in Deepak Agarwal. My submission there is, this issue never arose in Deepak Agarwal. Neither is the para of Rameshwar considered. Rameshwar relies on the judgment of the Allahabad High Court in Mubarak Mazdoor. Mubarak Mazdoor clearly says it is not in present time. There is no discussion or consideration of this issue in Deepak Agarwal. So therefore, my lord, this cannot be the ratio of the judgment at all. At best, it would be an obiter, my lord, is the submission.
There is no difficulty. We agree with you, subject to hearing the other side.
No, that's all right. But that's all right. But this is all.
Let us see Vijay Kumar Mishra.
Yes, please see Vijay Kumar Mishra. Vijay Kumar Mishra is at page 87 of this compilation. The fact at page 91, if your lordship will have.
Yes.
I need not spend time reading the facts. I have given your lordships the facts. It's exactly what I have told your lordships. Kindly come to page 93. Actually, I can read from para 3, page 92. Unfortunately, it was neither argued nor did the High Court examine the true meaning and purport of Article 233(2). The appellant's argument before the High Court appears to be that, notwithstanding the fact that they are members of the judicial service, eligibility for competing for the post of district judge should be considered on the basis of the facts that existed on the cutoff date, and subsequent events are not to be taken into consideration for determining the question whether appellants were barred or not. Then your lordship poses the question. We are afraid that the entire inquiry before the High Court was misdirected. The real question which arises in the case on hand is whether the bar under 233(2) is only for appointment or even for participation in the selection process. Then if your lordship will turn over to 94 para 7, it is page 94 para 7.
Yes.
It is well settled in service law that there is a distinction between selection and appointment. Every person who is successful in the selection process undertaken by the state for purpose of filling up of certain posts under the state does not acquire any right to be appointed automatically. Textually, 233(2) only prohibits the appointment of a person who is already in service of union or state, but not the selection of such a person. The right of such a person to participate in the selection process undertaken by the state for appointment to any post in public service, subject to other rational prescriptions regarding eligibility for participation, etc., and be considered, is guaranteed under Article 14 and 16 of the Constitution. Then at page 321, my lord.
But they also go on a wrong.
Totally contrary.
Correct. So
They say that there is a prohibition.
they proceeded.
Nothing but illusory.
They proceeded on the distinction between selection and appointment.
No, but they say that there is a prohibition for a in-service candidate to be a.
They say that you can resign.
If there is a prohibition appointment, how can he be eligible?
Just kindly
Eligible
see,
person cannot be appointed and then there's no partner. question of
yes,
participation.
kindly see page 96, para 14. This is what ultimately the court says. Page 96, para 14.
Yes.
For the aforementioned reason, appeal is allowed. Consequently, writ petition filed by the appellant stands allowed, directing the respondents to permit the appellants to participate in the selection process without insisting upon their resigning from the present employment. If the appellants are found suitable, it is open to the appellants to resign their current employment and opt for the post of district judge if they so choose. So that's the way out. Because, my lord, why this distinction? Because Deepak Agarwal is a bench strength of 3 honorable judges. So therefore, Deepak Agarwal was already there. Para 102 existed. So therefore, to overcome, this is the conclusion which the court comes to. So, my lord, in fact, the submission therefore is, if your lordship will come to my written submissions now.
Yes.
Now, my lord, there is one other aspect I want to point out to your lordships. Kindly have Deepak Agarwal, Dheeraj More, para 19, because that also is a completely incorrect reading of the judgment in Rameshwar, in Chandar Mohan. Please have para 19. Page 123 of the compilation.
It's not there in SEC, is it?
It's SEC. Page 123. The compilation I have given is only SEC.
Okay.
Page 123. My lord, before I read para 19, just 2-3 submissions I want to make. Chandar Mohan, your lordship, have read extensively in the morning. I have quoted those parts. There, the word judicial officer was a euphemism for executive officers. 3 times the court says judicial officer is a euphemism for executive officers. In Chandar Mohan, an argument was raised that if the third argument was judicial officer within actual executive officers are not eligible to be appointed in view of the ratio of the law laid down in Rameshwar Dayal. Alternate argument was if they can be appointed, actual judicial officers should also be appointed. Since the first argument was not accepted, second did not arise. While saying so, in Chandar Mohan, the court struck down Rule 14, which allowed judicial officers, in commas, actual executive officers, to join the service. Now, in para 19, in Dheeraj More, what the court reads Chandar Mohan to say, that because Rule 14 is struck down by a constitution bench, so therefore all judicial officers are out. This is not a correct reading. Though that judgment never dealt with actual judicial officers. Just see para 19, what is said in para 19, and I'll read my written submission on this. It is apparent from the decision in Chandar Mohan that this...
One minute.
Just see para 19, page 123, para 19. This, I'll show my written submission where I have exactly made this point. Just page 123, para 19.
Yes.
Just this is how this Chandar Mohan is actually discussed from para 15 onwards in 19. It is apparent from the decision in Chandar Mohan versus State of UP that this court has laid down that concerning district judges recruited directly from the bar, the governor can appoint only advocates recommended by the High Court. And Rule 14, which provided for judicial officers to be appointed as direct recruits, was struck down by this court to be ultra vires.
Totally incorrectly.
Correct. These judicial officer meant executive people. So now just
they go on a doctrine of separation of power, independence of judiciary.
Absolutely right.
They said that any person who is though called as a judicial officer, but in effect performing the executive functions cannot be permitted appointed as a district judge.
Absolutely. And see what they say further. Thus, this decision is squarely against the submission espoused by the in-service candidates. This is complete misreading of the judgment in Chandar Mohan. at page 4,
In Dheeraj More.
misreading of judgment in Chandramohan, in Dheeraj More, of Chandramohan, correct, in Dheeraj More. This point, my lord, I have made at page 4.
I would learn it, brother.
Yes.
In the above mentioned
In,
para 11.
in the,
Thus the decision is
pardon?
in paragraph 19.
Yes, thus, yes, thus yes, that's what I want. Thus the decision is squarely against the submission espoused on behalf of the in-service candidates.
Go further down.
All right. In the above mentioned para 11 of Chandramohan, the position is made clear. In Chandramohan, the court held that only advocates can be appointed as direct recruits. And inter alia rule 14, providing for executive officers recruitment, was struck down.
Rule 14 is for executive officers recruitment.
Correct.
They notice it.
They notice it and yet say that judicial officer is struck down. Correct. This court held that the expression service of state or union means judicial service. It only refers to source of recruitment. Dichotomy of two sources has been called out in this decision. This is complete misreading of the judgment, my lord. Complete. And my lord, if your lordship also
Doing violence of the finding.
correct. Now, kindly also now come to para 13 and 14, because there is one more proposition called out in these paras which I feel is not correct, my lord, at page 116. Here, they have, here, para 13 and 14 is the first time after noticing facts the court discusses. Now, kindly come to placitum F at para 13, page 116.
How do they consider Rameshwar?
Consider Rameshwar.
Rameshwar Dayal?
Yes,
It is
Rameshwar, my lord, is considered in para 20 onwards. Para 20 onwards and para 21, if your lordship will see what is said, I was going to come to that after this. If your lordship will see para 21. After noticing Rameshwar, Rameshwar is quoted in para 20 extensively. Then para 21 at page 126. It says, much was tried to be made based on the facts of Harbans Singh and P.R. Sani in the decision of Rameshwar Dayal. Now, your lordship has seen those facts. In fact, P.R. Sani was a chairman of the Improvement Trust.
Both of them were government officers.
No, one more fact. P.R. Sani was chairman of the Improvement Trust. His license to practice was suspended on that day. Yet the court holds, because they were advocates, they continue to be advocates and have declared them to be eligible. In spite of that, my lord, at page 127, after noticing, the extract is there, then after noticing, two of them were not in judicial service as on the date of their appointment. They had practiced earlier for the requisite period as advocates, later were appointed as district and session judge. Harbans Singh was working as deputy custodian evacuee property when he was appointed as district and session judge. In 58, he was appointed additional judge. At the relevant time when appointments were made, recruitments were permissible from executive service too. That's correct. Their eligibility to be appointed was tested. The question which came up for consideration was not whether they could have been appointed being in service of custodian of evacuee property or improvement trust. What was held by this court concerning interpretation of Article 233 in the above mentioned para 12 by a constitution bench goes squarely against the submission raised by the in-service candidates is something which is not really borne out from these paras at all.
So their eligibility to be appointed as decision was tested. The question which came up for consideration was not whether they could have been appointed being in service of the.
This is not correct. This was there was a direct.
As a matter of fact, they were holding that those posts.
Correct. There was a direct challenge to their appointment, which challenge was repelled and their appointment was affirmed. Of course, they had in the meantime been appointed and two of them were holding, were judges of the High Court at that time, when by the time this case got decided. Now, one more fact I want to point out. In paras 13 and 14, the requirement of 7 years has been married to the condition of not being in judicial service. If your lordship will see 13 and 14 at page 116, this also does not flow from 233. If your lordship will just see para 13 and 14. Para 13. All right, my learned friend says first line, para 13 at page 116. Article 2, My lord, sir.
Yes, yes,
Page is, my lord, 116.
yes, yes. Please.
Article 233(2) starts with a negative stipulation that a person who is not already in the service of the union or the state shall be eligible only to be appointed as district judge if he has been an advocate or pleader for not less than 7 years, is recommended by the High Court for appointment. My lord, I am running out of time. Just kindly come to placetum F. Requirement of 7 years experience as an advocate is qualified with a rider that he should not be in the service of the union or state is not a correct interpretation at all, my lord. This is carried forward again in para 14, second line, first two lines. Article 233(2) provides if an advocate or pleader has to be appointed, he must have completed 7 years of service. It is
Where are you reading?
para 14, first two lines. Article 233(2) provides if an advocate or a pleader has to be appointed, he must have completed 7 years of practice. It is coupled with the opening part that the person should not be in service. There is no, with great respect, my lord, there is no such marriage or coupling in the provision.
And what are this to do with Article 50? They have reproduced Article 50.
Correct. And
The separation of judiciary
correct,
from executive.
correct. The person in service, so once he has. So, my lord, this is regarding Dheeraj More, my lord. In my written submission, my lord, I have actually dealt with the correct interpretation of has been. Just kindly allow me to read to your lordships one part of it. The other is all judgments. Your lordship will see, my lord, I have quoted all those judgments. But just come to page 14 of the written submission. Something very interesting. Page 4591, something very interesting. In Dheeraj More, the Hindi translation of Article 233 is reproduced. 4591 is the written submission. Your lordship has my written submission hard copy. Just kindly see, type page 14 at the top. Just 1 minute. All right, page 4591, my learned friend says. 4591. No, there is an internal page here. Okay.
It's in para 7.
Now, para 7 of the submission, my lord, the review petitioners also seek to rely on the Hindi and Punjabi version of article. Your lordship got this line, my lord?
Yes.
Of Article 233 of the Constitution. The Hindi version of the Constitution has been quoted in paragraph 7 of the judgment in Dheeraj More. A reading of the same would show that the expression used is pleader raha hai. In Hindi, it says pleader raha hai. It is submitted that the expression is raha hai and not hai. Therefore, the term raha hai denotes a past state of affairs and not a present one, and is not necessarily continuing in the present. As noted in para 9 of Dheeraj More, the Hindi translation of the Constitution was signed by the members of the Constituent Assembly and therefore must be treated as an authoritative text. Now, the next is, my lord, what we have got from the petitioners have also got Punjabi of this article from the website of the Legislative Department. The expression used in the translation is reh chukya hove. Reh chukya hove is clearly past tense. So therefore, my lord, if your lordship agrees with what my learned friend Mr. Jayant Bhushan is saying and answers question 4 in our favor, nothing of this will arise. Assuming your lordship does not, then also I say, for a person like me who has 7 years service, who has joined and then is willing to resign his assignment, his service, and join as a fresh recruit, merely because I have been joined, should not be held to be a disqualification for my even being allowed to compete for the post. I am very grateful, my lord. I have tried to make the written submission comprehensive the way I want to project it before your lordships.
Thank you.
Very great.
Wait, please. Lord, the item number is 501.15. His name is Dheeraj More.
You are Dheeraj More.
I'm Dheeraj More.
Yes, sir.
Your item number is
501.15.
15.
Yes.
Okay, just a minute.
Yes.
May it please.
Can I be excused only for 5 minutes? 5 minutes, if I can. For 5 minutes, if I can be excused.
No, we are not stopping anyone to. We have been seeing Mr. Shankarnarayan is sometimes here, sometimes the central chair is vacant. Yes, his presence and absence both are conspicuous.
Yes. Yes, please.
My lord, petitioner was enrolled as an advocate on 3/8/2000, only two, just as. And then he became a
Enrolled on
3/8/2000.
Having 12 years of experience.
And then, my lord, he became an assistant public prosecutor on 2/4/2006.
on
2/4/2006. And then, my lord, on 2/4/2008, he joined the Haryana Judicial Service. And then, my lords, on 8/9/2009, he joined the Delhi Judicial Service. He had more than
On-
7.5.
He had 7.5.
no, when did he join Delhi?
Delhi, my lord, on 8/9/2009. That continued, my lord, and thereafter he applied for direct selection as district judge, and then ultimately the matter reached this honorable court, where this honorable court held, my lord, in Dheeraj Moore, that he was not continuing as an advocate on the date of a selection or even application or appointment, and therefore, my lord, he is ineligible. This is the sum and substance of. He therefore had 7.5 years of service in the bar, my lord, when he had before he joined the judicial service also. But, my lords, since your lordship, sorry,
If you include the APP's practice, then he had 7.
yes, including, only if that is included. Your lordships are right. Yes. If your lordships are considering issue number 4 on a broad spectrum basis, and then your lordships are pleased to answer it on the ground affirmatively, then, my lord, none of the other questions may really arise. And therefore, my lord, the question is, what is it that your lordships would be considering in question number 4? No, my lord, in my respectful submission, my lord, Dheeraj Moore may be erroneous, my lord, on 2 or 3 broad grounds. Firstly, my lord, to say that there is a 233(2), Article 233(2) provides for a quota for advocates, my lord, insofar as appointment to the post of district judge is concerned. 233(2) doesn't provide any. My lord, that's a reading of the constitutional provision, which, my lord, in my respectful submission, may not appeal to your lordships. There is no quota that is contemplated here. My lord, 233 as a whole has been held to be
a self-contained court, my lord, in the earlier constitution bench judgments of this honorable. More particularly, Rameshwar Dayal. Rameshwar Dayal, my lord, specifically and pointedly considered the question as to whether an applicant to the post of a district judge under 233 is required to be an advocate or a pleader on the date on which, my lord, he applies for it, and the date on which he is selected and finds. Bar Council, my lord, on the date of selection on the date of appointment as a district judge, does not find them ineligible, my lord, to be considered. And therefore, my lord, upholds the appointment on a specific basis. The law dictum laid down by Rameshwar Dayal in that instance. Chandramohan comes about subsequently on the essentially dealing with the question as to whether the service which are rendered by executive magistrates could also be treated as judicial service for the purpose of Article 233, holds affirmatively that it can be. But Rameshwar Dayal, my lord, which is a constitution bench judgment, specifically considers this question as to whether persons who are in judicial service on the date of appointment, date of selection to the post of district judge, which is a selection under 233 specifically, can take note of the fact that they have been advocates, can rely on the strength of the service which they had rendered as advocates and hold that they can. It is in the context of a direct recruitment under 233. My lord, Rameshwar Dayal has been misconstrued, my lord, in my respectful submission, both in Dheeraj Moore and also in Satyanarayan Singh, my lord, which is also a 3 judges bench judgment. And how they, my lord, it has been misconstrued, if I may say so with respect, is to take, my lord, that these are two disparate streams. Advocates in one stream, persons in judicial service in the other stream, and therefore at no point of time can they be permitted to mix together or jump from one stream to the other, in which, my lord, Satyanarayan Singh has expressed it. And Satyanarayan Singh, my lord, has been specifically referred to in Dheeraj Moore in paragraph 21 onwards and has been followed in that behalf. And ultimately, it is that which is laid down as a dictum, my lord, in paragraph 45. My lord, in my respectful submission, neither the wording of Article 233 nor, my lord, Rameshwar Dayal can be considered as in any manner, my lord, persuading a bench which came thereafter to take a view to the effect that these are disparate streams, and therefore, my lord, a person in judicial service, though was preceded by the service as an advocate, whatever be the tenure of service, my lord, that's a different matter that arises in the context of question number 4. They should not be permitted to apply for a post of the district judge on the basis of a direct recruitment under 233. That in sum and substance, my lord, is a question which frontally arises for your lordship's consideration. If your lordships are pleased to hold that Rameshwar Dayal has construed it correctly, and that is in sync with your lordship's own reading of the constitutional provisions as such, then, my lord, Dheeraj
Dayal, if you rely on Rameshwar Dayal, then even the executive would be entitled to compete.
No, that, my lord, Chandramohan takes.
Therefore, you may rely on Chandramohan because.
No, my lord, I relied on Rameshwar Dayal essentially for saying that Rameshwar Dayal, my lord, is sought to be distinguished, my lord, in Dheeraj Moore, and in my respectful submission, Chandramohan and Rameshwar Dayal are read in tandem, and ultimately, my lord, in Dheeraj Moore,
on the contrary, Dheeraj Moore holds that Rameshwar Dayal and Chandramohan, they reject the condition raised on behalf of you.
Wrongly.
Wrongly, yes, therefore.
Okay. That's correct. That is not how, my lord, Rameshwar Dayal or Chandramohan read. But Dheeraj Moore, yes, says that this is what Rameshwar Dayal held, this is what Chandramohan.
That has been argued by.
Yes.
Also, that the finding of Dheeraj Moore.
Yes.
With regard to Rameshwar Dayal.
Yes.
And Chandramohan.
Yes.
Is not correct.
Yes. No, my lord, please have a look at Rameshwar Dayal once more. Manner in which, my lord, this question as to whether he should continue in service, whether he should continue as an advocate on the date of his application or selection. What is a finding? It was a frontal question. It is not an obiter. Specific question that is raised.
Both of them were already in service on the date on which they were appointed as district judge.
Yes. My lord, my submissions are restricted, my lord, only to this. Other things have been covered, my lord, and therefore I don't want to take up your lordship's time. Please come to Rameshwar Dayal once. And please come to the manner in which, my lord, Dheeraj Moore is misconstrued it, if I may say so with respect. My lord, could your lordships kindly go to the volume which Mr. Patwalia had handed over?
No, don't go to that because it has SCC online.
Very well, very well.
We were reading the SCR.
My lord, volume 1, page 98 of the compilation.
The second volume.
5-1.
Yeah. Volume 5. Point. It's like a second volume.
My lord, if your lordships are going by the pagination, at the middle of the page, it is, please come to page 104, because this starts at page 98.
Dheeraj Moore is in volume.
Not Dheeraj Moore, my lord.
So, sir,
Rameshwar Dayal.
Rameshwar thing is volume
5.1. 5.1. My lord, if your lordships would straightway come to page 104, because the paragraphs are not numbered. I go by the pagination, my lord, 104 at the middle of the page, the fresh paragraph starting therein. This is where, my lord, the court had my lord, focused on the issue. It would thus appear that of the 5 respondents mentioned above 3, namely Shamsher Bahadur, Gurudev Singh and Hansraj Khanna had their names on the roll of advocates of the Punjab High Court before they were appointed as district judges. In other words, they were practicing as advocates at the time they were so appointed. 2 of them, and this is where, my lord, the issue frontally came up for consideration. Harbans Singh and P.R. Sawhney did not have their names factually on the roll when they were appointed as district judges. P.R. Sawhney, it appears, had his name so enrolled on 20th of October 1959, that is after his appointment as district judge. We are inviting to this distinction amongst the respondents at this stage, because as will appear later, this distinction has some bearing on one of the arguments made before us on behalf of the appellant. Now, my lords, the next page, or the same page, my lord, the last paragraph. Now, the argument that the learned counsel for the appellant is ranged over a wide field, but the point for decision is a narrow one and depends on whether respondents 2 to 6 fulfill the requirements of clause 2 of article 233 of the Constitution when they were appointed as district judges by R1. That clause lays down that a person not already in the service of the union or the state shall only be eligible to be appointed a district judge if 1, he has been for not less than 7 years an advocate or a pleader, and 2, is recommended by the High Court for appointment. As to the second requirement, no question arises here, because admittedly 2 to 6 were recommended by the High Court for their appointment. Then, my lords, please come down, and then a sentence which starts in the same paragraph. Secondly, that is after the Legal Practitioners Act is referred to. Secondly, he has submitted that by reason of the use of the present perfect tense has been, in clause 2 of article 233, the rules of the grammar require that the person eligible for appointment must not only have been an advocate or pleader before, but must be an advocate or pleader at the time he is appointed to the office of the district judge. Therefore, this is a pointed issue. Yes. Now, after this, my lord, if your lordships kindly come to page 110 in the middle. The paragraph which starts there, the fresh paragraph starting therein. And towards the middle of that, after article 124 and 217 are referred to. And this is where, my lord, the court says, and this is a much quoted provision, statement, article 233, if your lordships have got it. Article 233 is a self-contained provision regarding the...
You are at 107.
My lord, 110. 110. Fresh paragraph starting at 110.
110.
That starts with the word learned counsel for the appellant. My lord, I'm skipping some of them. And then if your lordships come about 10 lines below that, the sentence starts with Article 233 is a self-contained provision.
That we have already read.
Yes. I just give me 1 minute, my lord, so that I can complete my submission.
On the contrary, when Mr. Bhushan was arguing,
Sorry. Yes. Mr. Patwali was arguing.
no, when Mr. Bhushan opened the argument,
Yes, yes.
we said that this directly reaches the point.
Yes. My lord. No, my lord. When your lordships kindly come to page 112, last line. My lord, why I keep inviting your lordship's attention to this is that this is a ratio. And this has been completely misconstrued, if I may say so, with great respect. When it comes to Dheeraj More. The last line at page 112.
It specifically says that if a person is in service of the union or state, no qualification is required. The qualification is required if he is not in the service and if he is an advocate, then that 7 years embargo is required.
That's correct. But to say that therefore, if you are applying as an advocate, the fact that you have been in service disentitles you to apply for the post because you are not an advocate on the date of the service, on the date of the application, is what ultimately my lord Dheeraj More comes to. That is nowhere my lord mentioned.
We find that Dheeraj More does not correctly consider both
That's right.
Ram
That's right. That's right. On this crucial aspect as to my lord present tense, present past tense.
Both the judgments have been misread.
Yes. Both Dheeraj More and Satyanarayan Singh, my lord, which is also part of this.
Around the Chief Justice pointed out,
Yes.
paragraph 110, which I think he wanted you to see.
Page 110. Yeah.
Settles the issue now. It says, subsection 2 of 233 deals with only lawyers and the qualification.
That's right.
231 is common, no qualification is prescribed. That's the only thing.
And,
if somebody has understood Rameshwar, there's no difficulty at all. And then subsequent judgment also someone rightly understood to mean with respect to service.
Delmore also says that.
He said,
Same thing, but only says that when you are appointing a person from a service, he shall be only from the judicial service.
Yes.
that's correct.
That
Because it draws a distinction to the earlier service where they, from the civil service also somebody has been taken.
Yes.
No, they clarified it.
You know, in 1985, there was a watershed.
your side can conclude today.
Sorry, my lord? Yes, yes.
Your side can conclude today.
I don't know, my lord. See. My lord, I'll take another 10 minutes. I'll stay within my allocated time. I won't go beyond that.
Fortunately, so far, everybody has been keeping the time.
Pointed.
No, we'll do that, my lord. I think all of us will do that. Unless, my lord, there is some issue which arises on which your lordships would require assistance. My lord, in which case, my lord, we may have to assist your lordships with some extra allocated time. But apart from that, my lord, I'll. In the service, and therefore advocates have to have 7 years of service. Persons in the service coming under 233, 1 or 2 or whatever it is, my lord, there is a constitutional provision which enables that such persons in service can also be considered for direct district judges. My lord, 233 speaks about district judges and the manner in which, my lord, the appointments will have to be made. When it comes to other posts, my lord, in the subordinate service, the wording is different. It comes completely under the control of the High Court in accordance with the rules that are framed, my lord, under 3 by the governor in consultation with the High Court. What your lordships have held, and that also, my lord, in a constitution bench judgment of Bal Mukund Shah, that when it comes to appointment both to the post of district judges and other services, my lord, in the subordinate service, consultation with the High Court, my lord, is mandatory. It cannot be otherwise. Even a paramount plenary legislation, my lord, in Bihar was found to be, my lord, not valid because the question of requirement of a consultation with the High Court was not satisfied. Point is this, my lord. Therefore, a constitutional provision, which is, sorry.
What we try to understand, what you are saying is right.
Yes.
Now, if you understand the scheme,
yes,
as we understand it,
yes,
it puts the judicial officer at the higher pedestal.
Yes.
That's the reason why.
Yes.
That is the reason why it did not prescribe any qualification, number 1.
Yes.
Number two,
Yes.
it has given to the respective high court to frame the rules.
Correct.
On the contrary, as a lawyer, whoever is to be qualified, it has been mentioned under the Constitution.
That's right.
So
No.
233(1) is meant for everybody.
That's right.
Who's to appoint, how to appoint. These are the general things, right, about the power and the manner which it can. That is again, when you have rightly said, governor in consultation with the High Court means High Court can frame the rules, which again, he was also saying that maybe he doesn't have an objection with respect to the number of years to be fixed. That is one part. The other part is with respect to the qualification with a specific reference to the lawyers.
That's right.
Therefore,
My lord, no, I was just,
understand subject to hearing.
though I am not strictly concerned with question number 4 because I don't require the benefit of a broken service being mixed. Because I already have 7 years of service, as my lord the chief just pointed out, as an APP.
Once you will hold the constitutional, the wisdom of the constitutional mandate is there.
Yes,
By placing it on a higher pedestal.
that's correct.
Because you know, when somebody is working as
Then it is a
role as
logical.
lawyer,
Correct. Your lordship
somebody
are
is
right.
working as judicial
That's right.
officer,
That's right.
you will see the experience will.
That's right.
go.
That's right.
So
And-
therefore, they consciously left it open to the High Court. How do you regulate it?
That's right. That's right. And therefore, my lord, there is a
Diplomat
constitutional.
comes to go into all these things.
There is a constitutional justification if your lordships come to the conclusion that in assessing the 7 years, 4 years or 5 years in the bar, and the remaining service, my lord, in the judicial service could be tagged along to consider whether the eligibility conditions are satisfied as such. There's a justification for this. Because your lordships are holding, and rightly so, if I may say so with respect, that the judicial service will have to be put on a pedestal which is higher than that, the service which you render in the bar.
In our little experience, we can tell you, just excluding the senior lawyers, I would say my law clerk is that 1 year of judgeship is equal to 5 years of being an advocate. In terms of sheer experience,
Oh yes.
the volume of work
Oh
what
yes.
you get.
Oh yes. Oh
It's
yes.
for everybody, I'm saying.
Oh yes.
So that is the reason why they consciously left it
Oh
open.
yes. Oh yes.
Then, as rightly said, there is no reservation here. You can't interpret it like this. 233 and 33(1), it speaks about persons.
And what you,
When
what,
you see 233(2), it
Correct.
speaks about person.
that's
It's
right.
in one category.
That's right.
It speaks for the A category,
That's
while subsection 1 speaks about all categories.
That's right. That's right.
So that's
And-
difficulty on this.
And therefore, my lord, when your lordships are actually putting that meaning, or lordships are infusing that constitutional justification on a reading of Article 233(2), your lordships are essentially culling out the meat of the matter and then putting it across. Saying what? This is what 7 years is required. But 7 years, how to compute the 7 years is a matter in which your lordships will have to consider whether the nature of the service that is rendered. In fact, the distinction between somebody serves for 5 years, then goes, and then serves in some other capacity. Your lordships rightly say no, because there is a complete disconnect. And that cannot be taken note of, my lord. It may be a hard case. Then he comes back after 3 years, serves for another 3 years, still doesn't complete 7 years, and then goes. But then, my lord, your lordships will not take that into account and then say he enrolled, he got himself enrolled some 15 years or 20 years ago. And therefore, his total service will have to be considered. Your lordships will not accept it. Why? Because it is a completely dissociated service. But why your lordships at the same time would accept a case where he has been in judicial service and therefore tag along the service which he has rendered for the purpose of considering whether this is eligibility under 233(2). Your lordships will take note of the fact that the service which he renders is in the same category. The spectrum is the same. That could be the constitutional justification. My lord, coming back to what Dheeraj Moore has held, just come to paragraph 45 alone, my lord. That's the conclusions 47. And this is where, my lord, we would respectfully submit that your lordships may have to
That has been read to us.
pointedly overrule. Sorry,
Para 47 has been read to us.
yeah, it has been read. Dheeraj Moore, you're taking something, reading something else.
Both para 47 of Justice Mishra's judgment as well as the judgment of Justice Bhatt.
That's right. That's right. Those do not lay down the law correctly, my lord, in my most respectful submission. Starting from paragraph 45. Yes, volume, Dheeraj Moore, if your lordships have it. We answer the references under the members of the judicial service of the state can be appointed as district judges by way of promotion or limited competitive examination. Fair enough. The governor of the state is the authority for the purpose of appointment, promotion, posting, and transfer. The eligibility is governed by the rules framed under 234 and 235. Fair enough. Under 232, an advocate or a pleader with 7 years can be appointed as district judge by way of direct recruitment in case he is not already in the judicial service of the union or a state. Obfuscates the service which he had rendered as an advocate prior to him entering into the service. And to that extent, therefore, my lord, what is mentioned in 4 also, for the purpose of Article 233(2), an advocate has to be continuing in practice for not less than 7 years as on the cutoff date and at the time of appointment as a district judge, which also, my lord, takes it beyond the date on which the selection itself is considered. Members of the judicial service having 7 years experience of practice before they have joined the service or having combined experience of 7 years as lawyer and member of the district are not eligible to apply for direct recruitment as a district judge. My lord, these 3 or 4 principles, my lord, culled out in paragraph 47 in our respectful submission, my lord, lordships may have to reconsider. The rules framed by the High Court prohibiting judicial service officers from staking claim to the post of district judge, again suppose reserved for advocates. The euphemism or what is stated as post reserved for advocates, where is anything reserved for advocates, my lord? By way of direct recruitment cannot be said to be ultra vires and are in conformity with Articles 14, 16 and 233 of the Constitution of India. My lord, I am not really concerned with the virus of the rules, my lord, in the Delhi Judicial Service because that doesn't contain this prohibition. At any rate, my lord, I don't fall within that.
It doesn't contain such a provision.
I think only 2 high courts contain this. And therefore, my lord, but since your lordships are considered on a broad spectrum basis, such rules, my lord, if they contain a prohibition, may not stand the test of Article 14 and 16. Firstly, for the reason that advocates do not have a quota. Secondly, when you are considering direct recruitment to a public service, and therefore 14 and 16 straight away apply. My lord, the rest of the things have been argued, my lord. I'm grateful to your lordships.
Yes, madam.
May I just request your lordships to take up Dheeraj more and just the Hindi part, because your lordship.
Para 7.
Para 7, your lordships. Your lordships will see the placing of the comma in Hindi, which makes it very clear that Rameshwar Dayal interpretation is the correct interpretation. Page 971, your lordships. Lordships, page 970 is the English and 971 is the Hindi. And we had placed this before the 3-judge bench also, your lordships. And your lordships will see subclause 2. It says, वह व्यक्ति जो संघ की या राज्य की सेवा में पहले से नहीं है, जिला न्यायाधीश नियुक्त होने के लिए केवल तभी पात्र होगा जब वो कम से कम 7 वर्ष तक अधिवक्ता या प्लीडर रहा हो और उसकी नियुक्ति के लिए उच्च न्यायालय में सिफारिश की है. So the only mandate in this is that anybody who doesn't belong to the judicial service as interpreted in Chandra Mohan, your lordships, will compulsorily require 7 years. As far as the judicial service is concerned, your lordships, the 309 rules which are prescribed by the High Court will apply, because that itself has to be an advocate, has to take an exam and so on and so forth. So 233(1) prescribes the rules which the High Courts will set out, your lordships. And thereafter, your lordships, if a person is ordinarily not coming through the judicial service process, your lordships, has to minimum have an advocate's qualification and practice as 7 years. So that is the import of 233, your lordships. As
That's what Rameshwar Dayal.
That's what Rameshwar. And
Qualification not provided for in-service candidates. Qualification is provided only for lawyers.
Grateful, your lordships. Now, your lordships, I just wanted to bring to your lordships notice that if the provision is interpreted the way it has been interpreted in Dheeraj More, what is the grave damage that is being caused to the entire judiciary, your lordships? Because I have just collated some data and some facts and figures, your lordships, to bring to your lordships notice that the violence to this principle, your lordships, will lead to a lot of problems, including there will no appointments on time, because Malik Mazhar provides that every year there has to be an appointment cycle, your lordships. Vacancies fall very, very short, and I'm not placing this without any evidence, your lordships. When the advocates category comes, then your lordships, the number of persons who are selected are far shorter than the number of persons that are required against the vacant posts. And those vacant posts, if carried forward, your lordships, then lead to further inefficiencies, and if they can't be filled, your lordships, then those vacant posts remain. Your lordships may kindly just take for a moment.
Now that we are on the eligibility now.
Yes, your
What you
lordship.
say is, I think it's a fact, because take it from us, we are far more experienced in that, because we
Absolutely,
also
your lordships.
have been part of it at different parts of
Yes,
time.
your lordships.
But we are on a different larger
So,
scale.
your lordships, what I'm saying is that if the language is to be read the way Dheeraj Moore has read it, then it doesn't take care of also of the fact when the quota breaks down, because the quota is a creation of all India judges. It's not a constitutional creation.
That's what my learned brother has been saying.
Yes, your lordships. The quota is not created by Article 233. Unfortunately, in Dheeraj Moore, it has been read to be created by 233, your lordships. That is the first point, your lordships. The second point, your lordships, some paras of Dheeraj Moore where the error is absolutely apparent, besides 45 and 47, your lordships may kindly come to para 13 at page 972. And I'm just extracting the grave errors.
Para
Para 13, your lordships,
of the during
of Dheeraj Moore, page 972 SCR.
we are having the FCC
The paragraph number is the same, your lordships, paragraph 13.
begins with Article 233 too.
Yes, your lordships, negative stipulation. Your lordships, the very first
But
sentence.
we have already read.
Yes.
Para.
What I'm pointing out, your lordships, is the last three lines, which is glaring error, which your lordships will probably put in inverted commas. Article 233(2) nowhere provides eligibility of in-service candidates or consideration as district judges concerning a post requiring 7 years practice as an advocate or a pleader. Requirement of 7 years experience for advocate or pleader is qualified with the rider that he should not be in service of union or of state. This qualification, your lordships, is read into 233. So three things have been read into 233 by Dheeraj Moore, your lordships. One is that judicial officers are excluded from consideration for the post. Secondly, your lordships, what has also been read into this is that the judicial service people cannot be considered for the post. So all these things have been read in. The other thing that has been read in, your lordships, has been in practice. So the cutoff date on which he must be an advocate, that is in para 14, your lordships. In fact, in para 13 itself, if your lordship just sees above Article 50 quotation, it also talks about that thus it is clear that the members of judicial service alone are eligible for appointment as against post of district judge, as the only mode provided for appointment of in-service candidates is by way of promotion. So LCE also in a way is given a go by. Your lordships, it says only by promotion, because LCE also is not just a time-bound promotion. There is an...
I didn't get your submission.
Your lordships will see in the middle of this paragraph. What I'm saying is these...
No, para 13.
Para 13 towards almost the end of it, your lordships, just about half a para before Article 50.
The requirement of 7 years experience.
Your lordships, where it says there are two separate streams provided. Your lordships had read this part.
Just
Article
G in the SCC.
So there are two separate.
Yes, your lordships. Now, all this is read into 233. Article 233 provides two sources of recruitment, one from judicial service and the other from advocates or pleaders. These are two separate streams provided. One is for persons in judicial service and the other is for those not in the judicial service of union or state and have practiced for 7 years. So it makes a clear chasm between the two. The expression in service of the union or the state has been interpreted in Chandramohan to mean judicial service, not any other service of union or state. So far, so good, your lordships. Now, your lordships, this sentence. Thus, it is clear that the members of the judicial service alone are eligible for appointment as against the post of district judge, as the only mode provided for appointment in service candidates is by way of promotion. Your Lordships, this is absolutely incorrect and has to be reviewed, Your Lordships. Then Your Lordships will kindly see.
Thus, it is clear that the members of the judicial service alone
Yes.
are eligible for appointment as against the post of district judge.
District judge, as the only mode provided for appointment of in-service candidates is by way of promotion. There is no such bar under 233. 233 doesn't say that judicial officers cannot compete for certain number of posts of district judges. No such parameter is set in 233. These are some parameters which some high courts made as rules and said that we will have first quota. First quota used to be 50-50, Your Lordships. Then Lordships revised it to bring in the LCE process, Your Lordships, to make it competitive.
It is saying is that's correct. What is provided?
Yes, Your Lordships.
That they want. One channel is only meant for judicial officers.
Yes, Your Lordships.
That's correct.
Yes.
But you are right. The other channel also is like an open category.
Please, Your Lordships. That's
Now, what Deepak More says is that one channel is for judicial officer, other channel is.
there's a complete separation which is in.
But one channel is for judicial officer is correct because nobody else can participate there. It's only a way of promotion.
Absolutely.
Whether merit seniority or seniority come merit, it's a subject to that. That's a different issue.
Because the argument that is raised from the other side is that if the advocates have a pure 25% quota, in fact, their entire emphasis is on quota. So they say if there is a 25% quota, then nobody can fluidly move into this. Whereas the rules provide, and in fact, if there are leftover vacancies, I have just made an examination, Your Lordships, about 4 to 5 states, and I'll just take Your Lordship's patience a little bit to show in Madhya Pradesh, Your Lordships, after the Chief Justice's conference in 2015, when this entire problem was discussed.
You are giving this statistics to the Chief Justice of India. He knows everything. We know that's we don't want to express it. We know what's the
Not at a public forum, so we have to face it, Your Lordships,
Very well.
for everyone's benefit. So, Your Lordships, 2015, the Chief Justice's meeting takes place in which it is deliberated and decided that every High Court, depending on the caliber of its district judges or the lawyers, Your Lordships, will decide as to how to have the best merit, Your Lordships. So, in Madhya Pradesh, Your Lordships may kindly take this volume 6A for a moment.
Tell us orally, we will not go because
That's not right.
I'll tell.
while interpreting
Yes,
the
Lord.
constitutional
I'll-
provisions, we did not go on the data.
Yes, yes. So Your Lordships will see that Madhya
And
Pradesh.
each one of us,
Yes, Your Lordships.
coincidentally, there is no member directly from the VAR here on the bench.
Yes, Your Lordship.
Everybody has had experience in his own high court.
Yes, Your
And some of us in more than one high court.
Because Lordships are very aware of the rules.
Yeah. Therefore, on the concern expressed by you, see, we agree with you.
Yes, Your Lordship.
That's a
Yes.
real serious problem.
So Your Lordships, what I'm driving to Your Lordships is that many high courts, especially Madhya Pradesh High Court, provides that when quota breaks down, when for 2 consecutive years you cannot find any suitable advocate, because Your Lordships, the figures are dismal. 1 out of 16 people are selected in the advocates category, Your Lordships. When it breaks down, and the breakdown point is also decided after 2 years. When it breaks down, then how do we fill these?
Let us not go into those.
Your Lordships. So if the eligibility itself is knocked off of these judicial members, Your Lordships, the efficiency of the service is at stake. That is the point I'm making.
Shetty Commission has already elaborately considered that, and we have
Yes, Your Lordships.
seen the report of the Shetty Commission.
Very well. Now, Your Lordships, one more point I wanted to make is para 33 of Dheeraj More, is where it very cursorily rejects our argument on Article 14 and 16, which is the deprivation of opportunity. Paragraph 33, Your Lordships. Because Your Lordships, if 233 does not provide a bar, if I have the qualifications, then I definitely have a
You
right.
did not tell us you are appearing for whom.
Your Lordships, I'm appearing for the category of people who were advocates for 7 years, and thereafter they sat for the judicial exams and got selected, and then they again sat for this selection, Your Lordships, in the advocates category.
Yes, serial number?
21, 501.21. Netrapal, Your Lordships, UP judicial officers. And the challenge had come, Your Lordships, with the rules which provided a bar. So the challenge to the rules have come from both sides, because some rules provided the fluidity of shifting and migrating, Your Lordships. But many high courts said that there is a clear bar and you cannot shift or move on to the other category. Lordships, just one line in paragraph 33, if I can read. It was submitted that promotion is no substitute for direct recruitment, as against the post reserved for direct recruitment, an incumbent can apply throughout India, whereas an in-service candidate can be promoted within the state. And there is no definite period for coming into the zone of consideration for promotion in higher judicial service. Thus, it was urged that direct recruitment is altogether different from promotion, and having practiced for 7 years, they have basic eligibility to stake their claim for the post reserves for advocates, pleaders, and they have additional experience of acting as a judge too. We find no room to accept these submissions. And the next line, Your Lordships, is what I have objection to. Once the Constitution envisages separate sources of recruitment, no case can be made out of deprivation of the opportunity. Once service is joined, one has to go by the service rules, and it was open to such an incumbent to practice and stake claim in various states while remaining in practice. It is a matter of two different streams of recruitment which is permissible. Such an argument cannot be accepted.
Okay.
The other aspect, Your Lordships, which I will not cite, Your Lordships, but I put in the compilations, is with regard to the pragmatism of the interpretation of constitutional provision. And just one figure, Your Lordships, that we have only 21 judges to every 10 lakh people, Your Lordships. That being the situation, Lordships are always at pains that even one vacancy should not be left, Your Lordships. Given that aspect, Your Lordships, if there is a bar which is read into a provision, Your Lordships, it's going to be very, very against the judicial efficiency, Your Lordships. I'm very grateful.
May it please your Lordship, my Lord, I appear for the state of Kerala in the first case of Rajneesh versus Deepa. My Lord, Mr. Naidu is appearing for Rajneesh. So, my Lord, I will not take too much time on the facts. My Lord, we all have a restriction of time. So, my Lord, I'll leave it to him, my Lord, to give you, go into details.
Time. You have to begin at 3:45, you are beginning at 3:30.
Yes, my Lord. My Lord, we have taken your Lordship's injunction very seriously.
No, she has given you 15 more minutes.
No, my Lord, I'll try to conclude in 15 minutes, my Lord.
No. Vibha Datta Makia, ma'am, she was allotted half an hour.
Lordship.
She concluded in 15 minutes. So you have 15 more minutes. Or Dr. Singh, we can begin today after you. Yes, brevity of words.
We appreciate that.
My Lord, whatever your Lordship says, my Lord, I am prepared to.
Lord Pope. Lord take little delight from garnish of words and garnish of flowers.
My Lord, actually, my Lord, the theory that councils should be allowed to continue at length is not correct, my Lord. The very same councils before your Lordship, when they appear in international arbitrations, are given very definite time slots, and they very happily, my Lord, fit into that. If your Lordships were to insist on it, my Lord, I believe, my Lord, there will be no difficulty, my Lord, on our side.
But even in the last constitution pages, we except only 2 hours were extra. Otherwise, we finished within the time schedule.
Yes.
And this we think that we are unnecessarily granted more time.
Correct.
We could have concluded within 2 days.
Sometimes it's not more time. Problem is how to last during the time which your Lordships have. If questions come from all your Lordships, the question is how far are we going to survey for this half an hour?
Especially when your lordship's view already falls, your lordships, then there is not much for us to say.
That's always difficult for the third or fourth council. And the starts can take his own time. So. Yes, please.
You are 50.1.
Yes. Rajneesh versus K. Deepa, and the respondents will not include the state of Kerala. Now, Rajneesh was a person, I will summarize, my lord, the fact in one sentence. There are details, of course, my lord, which the counsel for Mr. Rajneesh can give your lordship, my lord. Rajneesh, my lord, was an advocate. After putting in 7 years in the profession, he took the examination and became a civil judge. Subsequently, when he was serving as a civil judge, he took the examination for direct recruitment as a district judge.
No, that's not correct.
I'm sorry, my lord.
He did both when he was an advocate. Both he did as.
My lord, I bow down to what your lordship is saying, my lord. I'll correct myself to that extent, my lord. He did apply for, my lord, the to appear in the examination as a district judge when he was still an advocate. But, my lord, his appointment came after, my lord, he was already serving as a civil judge. He was, my lord, I'm sorry, my lord, not civil judge, Munsif magistrate. So, my lord, this person, my lord, was then given liberty by the High Court on his application to demit office, my lord, as a as a Munsif magistrate and get posted, my lord, as district judge. This was challenged by Deepa and some others, my lord, and the High Court, my lord, held, the learned single judge held that this could not be done. The division bench held that, upheld that judgment. Now, those are the very short facts, my lord, of the 4 questions which your lordship has raised.
So whether that Rajneesh is in service now?
Yes, he is in service now.
He is protected.
He is protected
by this court.
Yes, he is in service now, my lord. And what is more, my lord, the state has taken a stand categorically in his favor. Now, my lord, therefore, I am only going to address your lordship as the counsel for the state on A and B questions. Not on C and D questions, my lord. I am not concerned with that. A and B question, whether a judicial officer who has already completed 7 years in bar being recruited for subordinate judicial service would be entitled for appointment as additional district judge against the bar vacancy. Whether the eligibility for appointment is to be seen only at the time of appointment or at the time of application or both. I will not address, my lord, the other 2 questions. Now, my lord, 233, as your lordship has seen many, many times now, has 2 conditions. One is, I am going to call that, my lord, the 7-year rule. And the second one is, my lord, the in-service rule. These are the 2 parts, my lord, of 233. On 7 years rule, my lord, my respectful submission is that the judgment in Vijay Kumar Mishra is correct for the reasons given there, particularly, my lord, 4 paragraphs, my lord, of the judgment of Justice Sapre. If I may just place, my lord, those 4 paragraphs, my lord, and move on from this topic. The proposition is that
given is that selection and appointment.
Yes.
Are 2 separate things.
Separate things, and appointment only takes place when he is actually appointed. The question, my lord, is whether the proposition that we are therefore making is this: a candidate can become eligible under Article 233(2) of the Constitution after putting in 7 years of practice, but the same does not have to be continuous leading up to the date of the appointment. It can be 7 years at any stage of his working life. This is the proposition.
So you want to adopt the argument of Arvind Datta that suppose he practices for 3 years and then goes back somewhere for 10 years.
Yes.
Again practices for 4 years.
Yes.
Will be eligible.
He would be, my lord. Because, my lord, he has put in 7 years at some stage of his career. But of course, my lord, as far as this particular person is concerned, he has put in 7 years continuously. But there is a gap between him putting in that service and, my lord, the appointment. My lord, my lord is absolutely right. He would. What? There is no gap between the application and the advocacy.
On the date of the application, he had continued.
He was,
serving as a
yes, correct, my lord. But, my lord, on the date of appointment,
Prima facie, we are of the view
yes,
is that the eligibility has to be considered on the date of the application, not on the date of the appointment.
very well, my lord, but I'm submitting, my lord, that even if on the date of appointment, my lord, even if there is a gap between the date of application and the appointment, and even if your lordship were not to take that period as being, my lord, covered, even then 233 is satisfied. That's what I'm submitting, my lord. Because,
Sorry.
yes, my lord, just let me place those 4 paragraphs, my lord, of Justice Sapre's judgment. Vijay Kumar Mishra, your lordship is looking at from page 76, 876, volume 3. Paragraph is 21 onwards.
Justice Sapre would start from para 50.
Yes, correct, my lord. Justice Sapre starts from
You want to read from para 21.
21.
Mr. Ranjit Kumar.
Mr. Ranjit Kumar, because he, my lord, makes a very pointed submission. Mr. Ranjit Kumar, Solicitor General, appearing for the respondent, High Court, however, contended that the word appointed occurring in 233(2) of the Constitution should necessarily include the entire selection process, starting from the date of submitting an application by the person concerned till the date of his appointment. It is his submission that if any such person is found to be in the service of the union or the state, as the case may be, on the date when he has applied, then such person would suffer the disqualification prescribed in clause 2 of article 233 and would neither be eligible nor to apply nor be eligible for appointment to the post of district judge. So clear, my lord, submission. Para 22. This submission, though looks attractive, is not acceptable. Neither the text of the article nor the words occurring in article 233(2) suggest such an interpretation. Indeed, if his argument is accepted, it would go against the spirit of article 233(2). My learned brother, for rejecting this argument, has narrated the consequences which are likely to arise in the event of accepting such argument, and I agree with what he has narrated. In my view, there lies a subtle distinction between the words selection and appointment in service jurisprudence. Praful Swain is referred to. When the framers of the Constitution have used the word appointed in clause 2 of 233 for determining the eligibility of a person with reference to his service, then it is not possible to read the word selection or recruitment in its place. In other words, the word appointed cannot be read to include the word selection, recruitment, and recruitment process, because they were trying to, my lord, injunct the whole of that process. In my opinion, there is no bar for a person to apply for the post of a district judge if he otherwise satisfies the qualifications prescribed for the post while remaining in service of the union and state. Well, it goes further than saying that a person has applied when he was an advocate, but he has been appointed when he was in service. It goes beyond that and says that even if you have applied on the date when you are in service, it is perfectly all right. It is only at the time of his appointment if occasion so arise that the question of eligibility arises. Eligible is only to be seen on the date of appointment. Denying such person to apply for participating in selection process when he otherwise fulfills all conditions prescribed in the advertisement by taking recourse to clause 2 of 233 would, in my opinion, amount to violating his rights guaranteed under 14 and 16. It's a settled principle of the rule of interpretation that one must have regard to the subject and object. To interpret a statute in a reasonable manner, the court must place itself in the chair of the legislature. So done, the rules of purposive construction have to be resorted to so that the object is fulfilled. Similarly, it's also a recognized rule of interpretation, etc. So,
we heard you that it may not require further elaboration.
Lordship.
You may be subject to hearing them maybe we may not be inclined to go into this. Perhaps it might become academic.
Certainly, my lord. My second submission is, my lord, with regard to the in-service condition. The so-called in-service condition, my lord, in my respectful submission, is really a matter of form rather than substance. It can very easily be dealt with in the facts of any given case. I'll take, my lord, this particular case itself. The Kerala rule says that appointment is on the date he joins a post. So when he joined the post, after, my lord, he was discharged or allowed to step down from, my lord, the position of a municipal magistrate. It is not the date on which he is offered the employment that, my lord, is relevant. This, my lord, helps us because on the date when he is offered the employment, many of these people have been in service. They have then resigned or, my lord, have been discharged, whatever. Now, the reason why, my lord, I say so is this. Two things, my lord. Number one, my lord, ultimately, it is a question of, my lord, offer and acceptance. It's a contractual situation. So the letter which offers appointment is only an offer. At that stage, he is not yet an appointed judge.
So the contra interpretation accepted.
Yes.
Nobody would even venture to write the examination.
Exactly, my lord.
Not resign and come, and nobody can.
No,
say,
then, my lord, it's not practicable. It's not practicable.
Nobody would come.
Not practicable, but, my lord, legally also unnecessary.
To give up this post.
Yes.
Then he has to decide if he doesn't get into a district judge post,
yes,
he has to go and practice because he can't go back.
No, he has to go to practice.
Come.
He can only go and practice again, my lord.
That's correct.
So therefore, my lord, what we are saying is that treat it from a point of view of principle. After all, my lord, every contract of employment is a contract. So when he is offered that employment, that's not the date of appointment. It's when he accepts it.
It is like civil service, no IAS and IPS, you can write. You continue.
Yes.
You defer it and then you can write again.
Correct, my lord.
If you get postal service, you can still go for
You can
IPS,
go for a better thing.
You can go
Yes.
for IAS, you can go for IFS.
Correct.
The commission notes that and says in all these other services,
Yeah,
lower service.
No, no. We will not be necessary, but we were said interpreting a constitution.
Yes.
In common parlance, if a person who is selected as an Ayat Tahsildar can apply for IAS, central service.
Correct.
While he is working as a.
True, my lord. And here, my lord, what I'm saying is, my lord, there is no problem with him actually being in service. When he is in service, he is then offered employment in a different service. He then decides to accept it or not to accept it. But there can be a situation. I don't know.
His service that category will start from day one.
Yes, it will not. My lord, then what will?
You have to forgo whatever benefits or advantages, disadvantages of the past service.
That's all, my lord. That's all. But he will accept that appointment.
And then it will be disastrous for the institution also.
Yes.
Somebody
Then you will be losing, my lord. Your lordship will be losing. Your lordship will be losing somebody who is admittedly, my lord, a very competent person. Now, my lord, one thing I should show your lordship, my lord, this principle of acceptance and offer and acceptance is, my lord, confirmed, not this. My lord, the rule, the Kerala rule, my lord. Yes. What is it? So, my lord, page volume 4.
Just a minute.
Yes, I'm sorry. My lord, I want to show your lordship, my lord, the Kerala State and Subordinate Service Rules 1958. Volume is, my lord, 4.1 of your lordship's compilation. Don't have to take it, my lord, I'll read it because it is in support of this proposition. Definition 2.1, appointed to a service. And my read, my lord, In these rules, unless there is anything repugnant in the subject context, appointed to a service, a person is said to be appointed to a service when in accordance with these rules or in accordance with the rules applicable at the time of as the case may be, he discharges for the first time the duties of the post borne on the cadre of such service or commences the probation, instruction or training prescribed for members. So, my lord, only when he starts working on the service, my lord, is he appointed. The word, my lord, in 233 is clearly appointed. So, my lord, this is, my lord, what I wish to say about, my lord, the second condition in service. It's a matter of form. The substance can always be, my lord, achieved. For instance, my lord, you can even give a letter saying that we are offering you this subject to you accepting, or you can say that we are offering appointment. Now, there are three things, my lord, I will just state, my lord, and that's all that I wish to do, my lord. First of all, my lord, please remember that Dheeraj More gave a lot of weightage to the quota. Please remember, my lord, that the quota was not a constitutional requirement.
There is no quota as such.
233 has no quota. How did the quota come? Quota came because
Shetty Commission.
your lordships, my lord, went into the question.
All India Judges Association 1.
All India Judges, etc.
Association 1.
Yes.
20, 75, 25, 25.
All that.
Yeah.
And then 10.
Then 75.
25, 10.
75, 10 and 40.
40, yes. Yes, my lord. We have gone through that entire process, my lord, because All India Judges kept appearing in the list from time to time. It still is appearing, my lord. Now, what I'm trying to say is this, my lord, that quota is not constitutional. My lord, that quota is created because your lordships felt the need was there to create it. And mind you, my lord, the rules followed that creation.
Earlier to Shetty Commission and All India Judges 1 first judgment.
Yes.
The appointments were only through promotion.
Through promotion.
There was no direct district, there was no avenue for the lawyers to directly come in.
Does not.
It has been provided by the first judgment so as to give incentive
Yes.
to the lawyers to join and so that the fresh blood is infused.
Lordship.
So that quota has come by, not by the constitution, by our judicial pronouncement.
By judicial pronouncement.
Then to give some incentive to the in-service candidates, that LCDA came.
Limited competitive examination. Then it was found that the limited competitive examination was not producing.
Not having enough number of candidates.
Correct.
So
it was reduced.
25 was brought to 10.
Lordship.
Now we are again enhanced it to 25.
Right. And your lordship will recollect, my lord, after all that, the state of West Bengal had come before your lordship and said that our limited competitive category has been exhausted and will remain exhausted for a long time. Please allow us to go back to 25%. That was in the other matter, my lord.
That we already decided.
Yes, your lordship has decided that.
Because of the wording there, the judgment.
Yes.
It says senior civil judge.
Yes, and my lord,
Yes, now how do you interpret the senior civil judge?
Yes.
Now they say in some state they say 10 years as civil judge. Again, it will be of no use again.
Correct.
It will not enable fresh talent to emerge.
Yes.
You have to become from junior division to go to senior division. Language there for about 7, 8 years. Thereafter, by the time the candidates would get jaded.
Lordship, my submission is, the next one is that therefore, my lord, the rules were pursuant to your lordship's order. In fact, my lord, in order to give effect to the order, the state governments were all called and they all agreed to, my lord, develop those rules, create the rules. 1 or 2 states probably had, my lord, direct appointment at that point of time, but most didn't have.
In Bombay High Court.
Yes.
The civil judges used to be appointed directly from the bar.
Right.
There was no examination or something of that sort. It was sort of an invitation.
Yes.
Gujarat was part of Bombay first. So it followed the Bombay practice.
Yes. So therefore, my lord, there was some of it, but most high courts didn't have. Most high courts introduced it for the first time after your lordship's judgment and after the rule was framed in accordance with your lordship's judgment. So the question of, my lord, going the reverse way and giving an interpretation to 233 based on the rules, my lord, does not arise. The second thing I want to say is this, my lord. My lord, the second thing I wanted to mention is this. There is a lot of emphasis, my lord, again in Dheeraj More about cutting down somebody else's quota. My lord, in my respectful submission.
When there was no quota in the constitution,
My lord,
there is no question of cutting down.
right, my lord, that's my first submission. The second submission is this, my lord, that if on interpretation, your lordships are satisfied that this person, my lord, who has put in 7 years as advocate and subsequently has gone to the judiciary, if this person is covered by 233(2) and is capable of direct appointment, then, my lord, he is entitled to be part of the 25%. So it depends on the interpretation. If the interpretation is that he is outside direct recruitment, then there is a cutting down. But if he is inside the direct recruitment on an interpretation of 233(2), in that event, my lord, you are not cutting down anybody. It is only that the zone of consideration is larger.
It is not group centric or a community centric. It's
Exactly.
on the institutional, it's on institutional centric. No?
That's right.
The constitution, it facilitates every institution to flourish, which means, you know, you have to pick the best of the talent available. That's the objective behind it.
And there is nothing in 233 which prevents it. That's the submission. Well, those are my submissions. Not this.
So to start today or tomorrow?
As my lord,
Okay. Can you finish in 5 minutes?
I'll take 10-15 minutes.
So Marnapalli, you are on which side?
My lord, I didn't have the place that side, so.
That was, I was wondering, yeah, I was just wondering to see on that side.
By the Maharashtra.
When I saw you,
No, I didn't.
I recollected that our Nagpur chamber meeting.
I'll appear that side tomorrow for a few minutes.
Therefore, I was.
The lordship said, my lord, before.
There is a request on behalf of the advocates preparing for the judicial service to please allow the intervention on behalf of.
No intervention. Only those parties were there.
Yes.
Their career will be affected, Lord. So,
What career would be affected?
they are,
Just because the live streaming is there, somebody has to show that he is arguing in the case.
that is not, Lord.
No more intervention. Whatever timetable is given, that will be followed.
Please, your lordship.